We are back with the Kirby Clements, your favorite, your favorite. I'm going to keep saying this until eventually we get you to take these cases. Your favorite New York and Georgia criminal defense attorney. He's also an appellate attorney. And he is very, very knowledgeable. You guys love him, so I love him. And we bring him back whenever we need real legal answers, because I'm not an attorney. I only play one on YouTube. So when we need the real answers answered with actual expert licensed answers, we go to Kirby. We defer to Kirby. Okay. We don't defer to Law and Order and whatever else we do. All right. I'm not dressed in my normal semi-professional garb because I plan to go to the gym after this, and I have a lot to do today, so I don't have time to change clothes and do this, that, and the third. So I figured I would just come like this and then skate out when it's time to go. All right, so we're here today because and we all know this was filed way back in February. The original sentencing date was, if I'm not mistaken, I think it was February 6th or 8th. Excuse me, everything's a blur these days, but it was early February that the original sentencing date was. It did not happen. The sentencing did not happen because Jonathan's attorneys filed a few motions, one of which was the motion to set aside the verdict. And that means exactly what it sounds like. They basically want the judge, and he has until April 1st to make that decision to set aside the verdict. In other words, this never happened. Okay. If this never happened and the judge agrees that this never happened, this is complete layman's terms. Kirby's going to explain it to you in legalese. But if the judge decides that, okay, yeah, you're right, then there's no sentencing, right? There's no conviction. This never happened, okay? In plain English, okay? Plain layman's, everyday person's English. Oh, thank you, Barbara. Okay, before I even see, I have ADD too, so I was just briefing Kirby. We all have ADD, actually. Yeah. Neurodivergence is the wave in 2023-24. The chat throws me off heavy, so that's why I don't go live a lot. But I felt like this was worthy because I've done it a couple of times on other streams, and I feel like, you know, you guys can benefit the most out of Kirby actually answering your questions live. I did say in the short that I did prior to starting this today, please minimize the amount of chatting going on for now, just so that we can let Kirby do what he has to do, because we cannot keep him here for 4 hours. We just cannot. And that's not fair to him. And it's also not fair to those who actually want to understand what's going on. So you guys can chat amongst each other, but in terms of asking direct questions, let's let Kirby, you know, do what he does. And then as he's speaking, if something comes to mind, sorry, that's the teacher in me. This is, I used to be a teacher up until about a year ago. As things come to mind as he's speaking, by all means, ask a question. But please don't flood the chat with a bunch of questions, especially not those unrelated to what we're talking about, because I'm not going to be able to go all the way up the chat line and recover from that, because it gets really deep and I'll miss out on a lot of questions. Okay. So those are the ground rules. Again, hold your questions for, you know, as we go. Okay. Pam has a question. So that's an appropriate question, because we can ask that first, and then we will go into what exactly a motion to set aside verdict is. Kirby, I put the question up on the screen. We'll go into what that is first, answer this question second, and then third, we'll let Kirby. Most of you have already seen the motion to set aside verdict. We'll put it up on the screen as well. We're not going to read through it. I provided the link for the motion to set aside verdict in the show notes, so you can go in there and click on it and read it at your leisure. But Kirby's just going to explain what one is, what this one is asking, and what can happen after that. Okay. All right, let me share my screen really quickly just to help us. So would help if I had it up. But Kirby, while I'm doing that, can you answer Pam's question? She says, if the judge sets aside the verdict, will there be a retrial?
The answer to that is no. If the court sets it aside on the basis of the sufficiency of evidence. That is, there's a concept in the law called double jeopardy, and we've all heard of that. No person shall be placed in jeopardy twice. Now, jeopardy attaches in a jury trial or when the jury is impaneled and sworn. So once you get a jury and they're impaneled and sworn, jeopardy has been deemed to attach. Now, you can't be retried on that case if you get found not guilty or for that same act or transaction. That's jeopardy. But if your conviction is reversed, and I'll give you an example. I got a guy's murder conviction reversed in Georgia, and so now we go back, and it's like, well, they reversed it because of some legal error, and because there was a legal error, the court said the evidence was sufficient to convict them, but there was a legal error that affected the outcome of the trial. So if the court in this case reverses because of some legal error, that is, we submitted an improper charge, there was some evidence that the jury heard that they shouldn't have heard, or the jury was precluded or not allowed to hear some evidence, and I think now, looking at it, that should have come in and it affected the outcome, then you can retry him, and jeopardy doesn't bar that. But if the court says, you know what, we let this go to a jury, the jury found him guilty, but really the evidence that's not, as a matter of law, that's not the crime, then you can't retry him. Or for some other reason, not going to whether he was some other technical reason not affecting the determination of guilt or innocence. So that's really it. So if the court, he can be retried if it's just an error of law, but he can't be retried, cannot, if they say that the evidence was insufficient.
Okay, now to that end, that'll segue us into this motion to set aside verdict. In your professional opinion, because we can read it all day and completely misinterpret it, because again, there are a lot of ambiguities in law and in legalese.
Right.
For this question, for what you just said, is this what this motion saying? Is this motion saying there was an error? And say that again, error in
law?
Error in law, or is it saying there was an evidence issue?
It says both. And that's that. And with any appeal, you raise both. You raise everything, because if you don't raise it, you waive it. Well, you got to raise it. I'm just going to tell you how it goes. At trial, you have to raise all of your objections and to preserve them. If you don't raise them, you waive them. So if they objected to something, or they said, Judge, we want to go left, and the judge said, we're going to go right. Great. We had a fight. We had a disagreement. We preserved that thing that we're going to call error. And so you list your specific errors to the appellate court. In Georgia, we call it enumerations of error. But the basic concept is we're going to tell you the specific things that were mistakes. In this case right here, they have listed factual errors or deficiencies with the case, and they have listed legal errors. That is certain, applying the law to this case, this won't work. And also that the court erred in submitting both, two counts, one of reckless and one of intentional to the jury, and also of not granting the justification. I think it was a justification charge. I have to look at my notes over here. I've had a lot. I mean, I've been traveling the state all last week, but
no, that's fine. Look, we like the real, we like the the live and action aspect of it. So do what you got to do. But you can look at your notes.
Okay. But yeah, so the bottom line is they've raised both. I will say this, as it relates to the sufficiency charge, you have to understand something, that standard does not allow the court, the appellate court, or even the trial judge at this point, to substitute their judgment for that of the jury. That is, Judge, we think this person was not credible at all, and the jury should have found this person was not believable. Well, the judge doesn't get to come in there and go, you know what, I ain't like that witness either. And even though the jury found them guilty because they apparently believe this person, I don't believe him. So I'm going to superimpose my judgment and say that person was unbelievable. That is not what this motion or an appellate argument could accomplish. The courts don't do that. They don't armchair quarterback. They just look and they go, well, we're going to find out whether the evidence as introduced supports that verdict. Not whether it outright is, that's the only, doggone it, by God, yes. It could really be, yeah, it does support it. So you can go from weak all the way to absolutely. But all of that keeps you convicted.
Right. Okay. So that being said, how do I want to ask this? Because again, we keeping it real. We keeping it, we keeping it a buck with you guys.
Right.
As much as we want. I mean, and just so you know, shameless plug, my birthday is in a little less than 2 weeks. 2 days after the judge has to make this decision. And honestly, that's all I want for my birthday is some positive news for this dude, because I'm at the age now where if I wake up alive, it's a good day. So I don't need anything but some good news for this guy, because we've all been, in the trenches since a year ago with this. And, we want to kind of see this baby come into the world, this baby of positive news come into the world after carrying it for almost 12 months. So that being said,
and can I jump in right quick just to clear something up? If you read the brief, one of the things that they talk about, just kind of dovetails with what I just said, is they talk about the fact that Jabari's testimony was different from the cab driver, Mr. Sarwar. And they're saying Sarwar didn't see something and didn't say this, but Jabari said that he intentionally did these acts to them. So now that argument kind of is a mixed question of law and fact, because what they're basically saying is you can't find recklessness when the only evidence is intentional. And thus, since the evidence was intentional and the jury found him not guilty of the intentional,
how can he be guilty?
You cannot therefore then say, well, they could then presume that he was reckless. You can't do that unless there was some evidence from, within the case that allowed that inference. But in this instance, the only evidence of the attack that goes to the attack was Jabari. And so she said it was intentional. He tried to hurt me effectively. He did this on purpose. He did these things with the specific intent. And that was sort of what the prosecution charged. So now the defense is saying, okay, so that's what you charged. And so now for the jury to come back with a reckless finding, they had to make up facts to come up with a recklessness argument. They had to exclude facts and kind of come up with their own theory when there was no evidence. Now, if there had been some evidence upon which a reckless finding could be based, and we have to see what the state's, what the people's responses to this is going to be, because obviously the defense is going to just put forth their version. But if that were the case, if the court said, you know what, there was no evidence of reckless behavior, it was nothing but intentional hitting, grabbing, punching, that was it. So yeah, there's no evidence to support a reckless finding unless they somehow find that the intentional acts were done in some reckless manner. But and obviously that would be the basis of recklessness, because you're doing an act. I got a bruise that you inflicted on me recklessly, as opposed to I got a bruise, you punched me in the eye. Well, that wasn't a reckless punch, now, because what happened? He told me I'm gonna punch you in the eye, and then he punched me in the eye. We find there's no evidence to assume recklessness, as opposed to he was swinging, he was trying to punch me and swinging wildly. So now it's like, he tried to punch you and he missed, and they're just swinging wildly with their eyes closed. Well, you can conclude, well, from that, he may have wanted to punch you, and the one punch that he tried to punch you with intentionally, he missed. But then he had his eyes closed and he's just swinging. So yeah, there's some evidence upon which to get to reckless. So that's sort of the first part of their brief, is essentially how they're arguing it. It was either intentional or reckless, but it could not be reckless because all the evidence is it was intentional and the injuries came from that intentional act, as opposed to, not looking wildly swinging.
Right.
That kind of sums it up.
Now, question: does that fall in line with inconsistent verdicts then, or is that am I out of? I'm obviously that would be like an appeal thing, but like, would that be considered inconsistent then? Because, like you said, your case was based on intent, but then you provided options for reckless, which is not intentional. You know what I mean?
I do, and I'll say the answer is no. And I'll give you a better way to think of it. Not a better way, the way that I've been thinking about it, because I'm in Georgia, we use this phrase. It's called a fatal variance. Fatal variance, meaning you said this crime happened this way, and I don't mean this is what the witnesses are going to say. I mean, the law spells out what specific elements you need to commit for the crime to be completed. You need to do A, B, and C. And in this instance, they listed like whatever the elements of the intentional tort or the intentional assault were. So you're going to have to allege these three things, and the state or the people alleged those three things. He did X, he punched her, in the car, causing injuries behind the ear, and he broke her finger. So you've alleged those specific things. Now, if you end up proving that those things were done recklessly, well, the due process required, it allows me or anybody who's being charged to know what I have to defend against. Right. You're saying I did this intentionally. So I'm here to defend against doing it intentionally. But if you then say, psych, we're going to prove that you did it recklessly or incidental to some other conduct, it's like, well, you didn't put me on notice for that. That could have been the reason that I was tried. In fact, that wasn't the reason I was tried. And so the proof differed from the allegation. Or there's a Latin phrase, allegata and probata, or allegata. I don't know. I never took Latin. I was, so it's allegata, alligator, or however you say it. It's just
crocodile and crock of shit. That's what I call it.
Whatever you alleged is different than what you proved. You alleged I was an ostrich, and you proved I was a penguin. There you go. Now, if you had alleged I was and you don't get to be saved by going, well, they're both birds. No.
Right.
For being an ostrich, and I came prepared to defend against being an ostrich, and I brought in all my witnesses that said this ain't an ostrich. And then you go, well, yeah, surprise, surprise, he's a penguin, and it's like, well, judge, give us the lesser included charge of being a penguin. That's not a lesser included charge. That's a totally separate thing. But so that's what they're alleging is a fatal variance between what was alleged, the intentional, and what the state or the government is now alleging was proved, which was reckless. And they're saying, well, those are different. Intentional and recklessness, different things. So there's a fatal variance is the way I would phrase it.
Okay, right. Okay.
Inconsistent verdicts is a little bit different. That's where, if a jury comes back with a verdict on two counts, one which alleges intentional and the other one that kind of suggests that you were justified in doing it. It's like, well, look, that's inconsistent. Either I could do it or I couldn't do it. That's a loose example I'm giving. But the basic point being is that I can't be guilty of both of those, or I can't be guilty of this and not guilty of that, because in order to be guilty of this, I'd have to be guilty of that. So it's sort of an inconsistent verdict.
Okay, got you. So there's your answer for that. For anybody that was, because I know we mentioned that months ago when we were talking about reasons he can appeal. And so that was one of many reasons that you could file an appeal on. All right, so I got a couple of questions, but before I put those questions up, you mentioned or alluded to pretty much the jury using creative license with how they got to their verdict. So to me, that goes back to all of that prejudicial evidence that probably had them filling in the blanks in terms of when you were mentioning what their thinking happened versus what evidence was presented to say what happened.
Yeah, well, now, and that's an interesting component, because we know that juries will make compromises all the time. Juries, and once you go back in the back, it's like, I don't think this happened, but I think that happened. But
you can't think yet. You have to base it on evidence and what was deemed evidence and admissible evidence.
But see, I'm going to say yes, but I'm going to go an extra step and add a little bit more to that mixture you just gave. It is the evidence, but it's also the reasonable inferences from that evidence. That is, if you say my options are, if you said the car ran the red light and struck the bicyclist.
Oh, I think you're freezing up.
I faded off for a second.
Yeah.
But
we got hit the bicyclist.
That's one where you go, right. So you hit the bicyclist and you go, well, it was done because I ran the red light. And so if either you got to find I ran the red light or I didn't. You can't conclude, well, he didn't run the red light, but he hit the cyclist. And so I'm going to, well, no, that's that. You making up facts now. The evidence, right. The claim involved running the red light. But on another count, the issue could still be, well, even if he didn't run the red light, the fact remains that a bicyclist was visible and in the area. And so on another count, you might charge reckless disregard because he had time to stop. He had a last clear chance. He was in the green light. He saw the cyclist come through. But what I conclude happened is he didn't run the red light, but he just figured that dude is himself jaywalking or jay-riding, and I'm gonna hit him anyway. Well, okay, that's a reasonable inference as well, provided there are lesser charges that include that. But if you just charge intentionally running a red light and struck the person and then don't prove that, then you're going to lose. But if you charge intentional running the red light and also just some sort of reckless act, and the jury concludes, I don't know if he ran the red light. It was a lot of witnesses out there, but I do feel from the evidence that they probably saw that cyclist. They saw the cyclist and they had time to stop, and they just decided to just blow through the green light, knowing that guy was going to be there and hit him. And so that would be acceptable for the jury to do if there was a charge for that. But otherwise, you just can't say ran through the red light. Well, I'm going to find him guilty of some other stuff that had nothing to do with the red light because I'm just making it up.
Right, exactly. All right, so we got a couple of questions real quick. This is not necessarily directly related, but it is so Ida, I always say Ida. I don't know why. I guess it's the Spanish Harlem in me. I think it's Ada, but Ida is asking if there's a retrial, does he have to do all 4 charges again or just the 2 charges? We already know it's just the 2 he was convicted of. But this retrial talk is only based on an appeal. There won't be a retrial for this particular motion if it's decided in his favor, unless we can beat that double jeopardy rule.
Well, close. And I will say we're real close. Here's the point. You're correct. He cannot be retried on the charges that he was acquitted for. That's absolute double jeopardy. I got found not guilty in the first trial and on those counts. So even if I win my appeal, it's not like the government gets a second chance to prove those counts that they lost. No, once they lost them, they're done. Double jeopardy bars those. As to the new counts, if the court reversed it on sufficiency of the evidence, no, double jeopardy bars a reprosecution. If the court reverses it on the remaining counts and it's on some error of law, not affecting the sufficiency of the evidence, then yes, he can be retried only on those that he was convicted of and that remain, but nothing that he was acquitted of, period.
Right. Okay. So there's the answer to that. All right. Let me see. I had one more question. Y'all are killing me in the comments. Yes. Jonathan cannot be both an ostrich and a penguin. He's an excellent actor, but he's not that great. Yeah. Okay. Yes. And like Flavio said, recklessness was prosecution's plan B. Funny Barbara. She says from an ostrich to a penguin was a new DreamWorks animated feature.
Maybe I'm starting a whole meme with ostrich and penguin. But
look, Jonathan, we got you.
I will tell you. Right.
Go ahead.
But as to that earlier comment that said that the plan B, absolutely. As a prosecutor, I will tell you, I charged, and as a defense lawyer, I've had it done to me. So this is the prosecutor's right. I will charge you with the crime as many different ways as I can. I'll allege intentional. I can also allege reckless. I can have fallback positions. Nothing stops me from doing that. Because if I allege intentional and you come into court and defend on reckless, well, I'd be a dummy to not have alleged reckless. I'm going to allege intentional. I'll allege reckless. I'll allege whatever variation is in there and try to get some evidence on any of those. Like, was he swinging? Yeah, you just try, even if you don't allege it, but you want it to be factored in. And the motion talks about this, that some of these things were not lessers, if you will, lesser included. It wasn't included in that charge. If you can get the evidence in that would justify the lesser included, then you can get the charge on the lesser included, even though you didn't allege it in the indictment. And so follow this. You got crime A, and I'm not going to use these crimes. I'm going to use glass of water. Full glass of water is the crime. Beautiful. But I also can allege quarter glass of water. I'm going to put in evidence for this much glass of water, water with ice. I'm going to put in all of this so that if the jury says, we don't think you've proven a full glass of water, I'll be like, do you think but I also produce evidence that there was a quarter glass of water in that full glass of water too. Didn't I, Judge? Yes, right. You did. Did I introduce some evidence that there was some ice in that? Yes, you did. All right, then. So the jury could get the charge of ice water, which is a lesser of full water. The jury could get a lesser included charge of quarter glass of water, which is a lesser included of full glass of water. And not just because a quarter is included in a full, but because I introduced evidence that before it was full, it was a quarter of the way full.
Exactly.
And now,
exactly. Okay, so Barbara has a question. Barbara, we're talking about the motion to set aside, right? So I guess she's asking, can the motion to set aside be granted, or the judge can do whatever he wants? But if this was a nice judge and an objective judge, can the motion to set aside verdict be granted since the judge didn't read the proper instructions, or at least all of the instructions?
The answer is absolutely. Meaning, and we froze when you were talking, but I see the question here, so I'll just go ahead and answer this. And that could be my connection here, and we got different weather down here in Georgia. But if you have an error of law, and an error of law can include admitting evidence that should not be admitted or excluding evidence that should have been admitted, you can also have an error of law with the jury charges. And when I was on here, I think the first time, maybe the second time, I told you that one of the top bases of getting convictions reversed are errors in the jury charge. That is, judge.
Hold on, you break. Okay.
You shifted the burden. You didn't properly charge them. You didn't read all of them. So any one of those combinations can result in a reversal if it affects the substantial rights. And obviously, a jury charge error does affect your substantial rights because we've heard the facts, but now we have to know what is the law that is to be applied to those facts. And if the jury, having heard the facts, is now given the wrong law, either incomplete, which doesn't properly charge them on what they are to consider, or they get more stuff than was charged. So now you've given the jury other grounds to convict this person, which weren't charged in the indictment and are not included as a lesser. So you've given the jury some other basis to convict this person, so you charge them too much law. You charge subsection C, and that shouldn't have been charged. So yes, those type of errors will result either too much, too little, or not enough, or that's not enough to say it's too little. Too much, the wrong, or too little, you will get a retrial.
Okay, now, was the motion leaning in that direction? For those who didn't, get a chance to, or it's a lot. It's almost 50 pages. I admit I did not read off of. I did not. So, I read a lot of pages. I feel like it did. I mean, because again, you throw everything in, including the kitchen sink. But at this point, it's kind of like we're all armchair / Monday morning quarterbacking, and it's kind of like the horse is already out. It is what it is, right?
Right. And I'll tell you this. The thing about appeals is that, well, there are trials and appeals. At trial, a lot of stuff happens and you're on the fly and you're really going.
Mm-hmm.
And so you got to make a decision and you anticipate how this is going to play out, but then the other side moves to exclude something or decides not to call a witness or whatever. And now things change. And so you got to adjust quick. So your brain's got to go quickly. You got to think properly. And then you move and you make decisions in the heat of the moment. But after the fact, when you're on appeal and you start making these arguments, the one thing that you can also rely on is if the prosecution said something at the trial phase to get a court to go a certain direction, and now they turn around and try to argue the other side, well, that's going to help you as a defense lawyer tremendously. You're like, Judge, look, the prosecution said this was the basis. This is why they were doing it. And so what we have right now is just the defense brief. And we don't have the prosecution's response, because once we get their response, then we'll know how they're responding. Are you all owning what you said at the trial and going to say the defense just got these facts wrong, or the defense has cherry picked out certain things for their position, which if you add the other stuff that also exists in the record that they omitted, then you will see that their motion fails because they just cherry pick certain things. That's one option. The other, and that's what we hope the prosecution would do. I'm not saying I hope the prosecution does it. That's what we would hope the prosecution would do. The thing that I've seen prosecutors do, and I have a friend who does appellate work as well, is sometimes they'll come in there and they'll argue something. You're like, wait a minute, that's not what you said at trial. You said this for this purpose, and now you're trying to argue that, well, besides that, also this. And then it's like, wait a minute, no. You got the trial judge going in a certain direction. So sometimes people will be mad at the judge, and it's like the judge is relying on the parties. And if you're the state or the people, and you told me this is what you're trying to prove, and this is what's going to come in, and I'm accepting that because you're an officer of the court. But then if later on, after I make a decision on that, it comes out, oh no, now you're going to try to argue the things that the defense said you were doing. You go, no, we're not doing that, Judge. Then on appeal, you go, that's exactly what we were doing. Well, that's going to be, and I've seen prosecutors do that. I mean, I've had them try to do that double argument thing on me, and I was, and I'm like, well, Judge, I appreciate what they're saying, but I like to turn you to page 37 of the transcript where I specifically said this, and you said, Mr. Prosecutor, are you, or Miss Prosecutor, you're not saying the following, are you? And they said no. So they are now precluded from doing a double round and coming back in and saying yes. So we're going to need to hear what the prosecution says in this instance, because both sides are on one point, on one witness's testimony, the defense is saying this is all she said and it was intentional. The prosecution is going to highlight what they think justifies the reckless charge. And so we haven't heard that yet, but the defense brief, I think, was very good. I mean, I'm just going to be honest. I read through it. I'm like, y'all, you quoting it, you're doing it, but I do know this. When I was a prosecutor, I had defense lawyers. I had defense lawyer file a motion, a brief on a case we argued before the Georgia Supreme Court. And even I was like, oh my God, because I had tried the case too. I tried it and I handled the appeal. So I'm like, oh Lord, I did that. And I mean, I was really like, I didn't remember. I had like, man, by the time that case came up, I had like 3 or 4 more murder trials. I'm like, I don't remember that at all. So I was just like, ooh, that's bad. Oh yeah, that is horrible. We're going to lose this case. And then I went back and read the transcript. I'm like, that's not what happened at all. And then I just pulled in the record and I won it on appeal. But the point being is that just because one party says it, you got to realize sometimes they're just picking out the evidentiary facts that just support their side. And we have to hear both sides to get a fair understanding of what's going on. And then sometimes you're just like, you can say whatever you want to say. This happened. And if this happened, this should be the outcome.
Exactly. Right. Now, this is just a matter of, and we already know this, but again, it didn't help. Aisha says that the only issue is she still has no idea how she received her injuries or the time frame in which they occurred. I'm adding, the teacher in me. So how are they inferring it about that it was during the scuffle in or out of the car? Because again, what he did get convicted of was what happened in the car, but nobody, including Grace, testified to knowing for a fact that that's when the finger and the ear injury occurred.
True. However, one can certainly say that there was no other opportunity from the video or the evidence that gave any other option for the injuries to have occurred. That is, if she got it cut behind her ear and she's like, look, we fought in the car. And when he got out the car, you see out the car on video. Did y'all fight outside the car? No. Did he hit you anywhere near your head or neck outside the car? No. Well, you don't know exactly when you got in the car. Well, no, nobody knows, in the middle of a fight, when you get that cut? During the fight. I can't tell you. Now, if I only got if I got a broken eye socket and the person punched me one time, we can all determine that's when it came from. But if it's just a fight and a scuffle, there's no requirement for you to give a blow by blow. A jury is entitled, remember, as I said earlier, all reasonable inferences that flow from the evidence. So a reasonable inference that flows from the evidence, to address her question, was, we fought inside the car. That's the only time you see it. So it's a reasonable inference to conclude that that's when those injuries occurred. Now, if the defense were to have brought out some other stuff that said, hey, no, she fell and hit her head later on, or she fell earlier, and now we start calling into question with specific things and not just
okay.
And follow me. Even if you give other possibilities, just she was drunk and fell on the steps. Okay, do you have somebody to say that she hit her head on the steps? No, I don't got that. I just know that she was drunk, fell on the steps. And she was in the bathroom and she was drunk and somebody found her on the floor. Okay, do you have any evidence that she hit her head on the floor? No, I'm just saying she could have done it on the floor. Well, could have done it on the floor is fine. But if you don't got anybody to close that loop, the jury has this option. Fought in the car, struck you in the head in the car. Some other fights and falls or whatever happened later, but no evidence that any injury occurred during those times. Injuries could have occurred, but no one said they did occur. Then and a reasonable inference is she was injured in the car during that struggle. So the state is not obliged to prove down to the exact second when an injury occurred, but it must be either from the direct testimony or a reasonable inference from the evidence that we do have, that a jury could go, no, I think what happened is y'all were fighting in the car and that's when your finger got broke. And I think it's also reasonable that, and given the evidence that we have, that you got hit behind the ear. Now, the finger is a little more questionable because there are other places I think that she could have hurt her finger. Like, I mean, when he got out of the car and he was walking away and he snatched away.
Say. This was 3 different times.
But the jury can reject that.
But see, that's where I'm kind of frustrated with the defense. I'm just gonna say it. Because those videos were played at least, at least up to and including during deliberations 5 to 6 times. In different ways, shapes, forms, snippets, full, short, long, close-ups, zoomed in, zoomed out, POV, different POVs. I just want to know why there was no. So I think what it was is that they relied too much on people having common sense. I think it should have been verbalized. She said 19 times that she did not know how she injured her finger or the crease behind her ear. Kirby, it wasn't a head injury. It was the crease behind her ear. She said 19 plus times that she did not know how those injuries occurred. She only testified to him pulling her arm behind her back and trying to get his phone. And then we come to find out she never got his phone. She tried to get it and he did not let her get it, but she never got the phone. She claimed she took it and turned away from him and he was trying to get it. And that's not what happened.
Well, stop right there. And I just got to stop you because I got to say the following. To be fair, if she gives a fight in the car and you go, well, you don't know exactly how you got that cut. No, but the only time I could have gotten that cut would have been in the car when we were fighting.
Or when she hit her head on the DJ booth, which that's another thing that nobody pursued. I'm like, are we going to talk about her hitting her head? Are we going to talk about her grabbing him 3 different times and him yanking away? And that could have been, or ripping his coat. And that could have been when her finger got caught in the coat and snagged and broken. nobody pursued that. They just relied on people looking at the video and making the putting two and two together.
And I will say that that's the part about trials when things are happening really fast. Sometimes you got to gauge it, because the other thing you got to recognize is that somebody can undercut that. Like, let's just take, for an example, I'm not going to say this happened in this case, but let's just take it as an example. Suppose you talk to the witness and you find out, yeah, I hit my head on the DJ booth. Were you cut? No, there was no blood then. Nobody saw it. And the witnesses, I didn't see any blood then.
Nobody saw blood at all.
No, I got that. But let's just suppose fresh after a DJ booth hit, a cut might be there. And nobody, and you as the defense lawyer know, people are like, no, I didn't really see a cut. You might not want to bring out anything more than there was and I'll give you this from something I learned. This is teach y'all how they teach us in law school. People say lawyers lie. It's like, we don't lie. We weren't there. We'll tell you how it works. You ask someone a question. You say, sir, where were you? I was looking through the front window and I saw the butler shoot the man. I saw the butler did it. I saw him through the window when he shot the guy. Defense lawyer, having been to the scene, knows that there are bushes in front of that window, but those bushes are like, 2 feet off the ground, and you got like an 8-foot picture window. I'm basically describing in front of my house. So
I was going to say, that sounds very Atlanta, but carry on.
Yeah, so you got this 8-foot picture window and these 2-foot bushes, and you looked in there and you saw it. So I don't ask you that question. Instead, what the defense would say is, were there bushes in front of the window? Were there bushes in front? Yes. You don't ask how tall they were. Was it nighttime? Yes, it was nighttime. Okay, you leave it at that. And then you argue to the jury, they couldn't have seen because of the bushes and it was dark outside. Now, that's not a lie. That's an inference, and the jury can conclude that. It may have been that the defense, in preparing for this case, knew that if they pursued that line of questioning, that the evidence may not have been as favorable towards them as they wanted. That's one option. The second option is, even if that was established, she hit her head on the DJ booth. Okay, you can hit the same injured spot twice. If you got bunions, I'm using bunions because my wife's a podiatrist. If you got bunions and somebody stepped on your toe, you know what I'm saying? It's like, well, so was your toe swollen and messed up before? No, my toe looked like all crooked like that because I got bunions. All right. So just because that evidence was introduced, the jury could still go, I get that she hit her head on the DJ booth. I even think she fell in the bathroom. It might have fallen on that side of her head. But I also believe that he hit her in the side of her head in the car. So the fact that those things exist, and understand it's in criminal law, and I see kind of where a lot of people go wrong in criminal law is they think like civil cases, civil is balancing. I'm thinking this way. It ain't that way in criminal. Criminal is just prosecution bears the burden of proof, up or down. So yeah, she hit her head on the booth. She fell. She was drunk. She don't even know how she got hit. However, looking at that video and all the evidence that we have, the only time that he could have inflicted these injuries were in the car. And therefore, that's what it occurred. Now, if they tell you other stuff that could have happened, that doesn't mean as a matter of law that you all can find him not guilty. It just simply means that the jury has to decide, do we think it occurred here and it was his fault? Or we think it occurred there? So just because there are two competing theories does not mean that he's not guilty, because the jury gets to pick.
Right.
Well, they're not even picking a theory. They're basically going, he's got a theory, but we don't care. We want to know, have they proven their case? And we're going to factor in, did they, what about this? Did y'all disprove this? The defense said it happened. Did you disprove this? Because if this is an issue, then you lose. But at the end of the day, it's your burden. And if she doesn't know where she got hit, but the evidence suggests that's the only place it could have happened, you just have somebody unhappy. Somebody's going to be happy and somebody's going to be unhappy.
Right.
That's just how it goes.
We know who's unhappy.
Yeah, we do know who's unhappy.
We're unhappy.
I'm on her show right now.
Yeah, I'm very unhappy. extremely unhappy. All right, so I guess because a lot of people want to get into this civil suit. That's a good segue that you mentioned the civil suit, but we'll give me like 5 minutes, hopefully, and then we'll get into the civil suit. I also have Lauren Burke. She's going to join us in a few minutes because she actually has more information about the state's response to this motion. So I'm going to bring her in a second. Okay, so I guess bottom line with this motion to set aside the verdict, did we ever explain what that meant? Let's go back really quick. Hey, Kat, if you want to join us as well, you can, because I know Kat is not an attorney, but she may as well be one, because when I tell you this girl, my ADD won't let me be great. She digs into like the inner recesses of the earth for information, and she analyzes it down to the last comma in the sentence. And I don't got it in me to do all that. That's why I call you. But she also is very knowledgeable about the state's response to this, because you did mention you wasn't sure what their response was, but she can tell you because it wasn't published verbatim, if memory serves, but there was some summary of what they said in a news article, a summary, and basically it was a lot of what they had already said during the trial. So they didn't even bring up anything compelling enough to sway the judge to say, oh no, that's sufficient enough for us to reject this. So I'm praying that, okay, so first, before I go off on my ADD tangent, first, let's explain. We got to backtrack and explain exactly what a motion to set aside verdict is. And then, see, I lost it already.
Well, I will say this. And I follow you because my daughter, with her college degree, not in psychology, has diagnosed me as ADHD. So I understand.
No, I really have it.
No. I actually, I'm 100% sure I got it too because of all the stuff that I do. And ever since I had COVID, it's gotten worse. But
yeah, me too. I got it twice. Asymptomatic, but I think it did something.
Yeah, it did. I had it twice too. There you go. Mm-hmm. So I will say this: a motion to set aside a verdict. Think of it like this: procedurally, you want to give before you go through the appeals process. Sometimes the appellate court says, "Hey, look, to ease our burden, let's let the trial judge have a chance to fix any errors." Like, look, why come to me if when they show you what happened, if you decide, you know what, that actually did happen, you're right, I messed that up. We're gonna give you a chance to fix it, and maybe you decide we should grant this guy a new trial, and now the state can certainly appeal that too, but it's a little different standard. And again, the goal being, we don't want to clog our appellate courts up, so let's hear it. And then also from the defense perspective and the prosecution perspective, you get to hear the analysis of the reasons. And so if you're going to appeal, you know, hey, look, we have some good grounds to appeal. And now that I've seen what the judge has to say, I think, and what the other side has to say, I think this is a good grounds. And I've done that. I mean, on the murder case I had, it's like, yeah, I went through a lot. I had like 30 grounds, but by the time we finished with all the evidence and the hearing and their response and then reading the judge's order, I was like, all right, I really don't got 30. You know, I got like 15. You know, 15 of them seem good, but aren't. And 15 of them are my best. And only 5 of those 15 are ones that are going to result in a new trial. So it helps you to refine it. That's why you want both sides and the trial judge to do it. But the goal is, why go through the expense and time of an appeal when when the trial judge can basically say, you know what, and as a litigant, from the defense perspective, not so much, but from the state's perspective, yeah, you know, you kind of know, look, all right, we did mess that up. I mean, and the judge is going to be like, look, counsel, I like to point out X, Y, and Z. And you know, when I was a prosecutor in New York, you had time to look at it and be like, all right, yeah, you know, that did happen. You know, we had a really good judge for the prosecution, but, you know, in the light of day, having looked at everything, it's coming back. So why do I want, you know, the judge granted it, let's go ahead and do it again, you know, because we can take our chances on appeal, but the judge has already granted it. And yeah, you know, and you go through. I mean, in New York, I got to remember the procedure, whether the state can appeal it. I know in Georgia, it happens all the time where, you know, each side can appeal. And sometimes you just kind of go, that's clear. I mean, the judge broke out the law is, or there's a case right on point, you know, like I'll just take a segue. Georgia just came down with a case that reversed a conviction where they introduced rap lyrics into the into the defendant's trial. So now
what is it? Why that YSL, whatever that whole group? I think you froze again.
So the fact that Young Thug is happening right now.
Okay, that's what I was thinking. Okay.
But it was a different case. But my point being is that decision came out after the introduction, I believe, of the lyrics in the Young Thug trial. But the defense lawyer in that other case raised it, and the court said, you know what? That was too prejudicial, and the appellate court reversed that conviction. So now already we know, you know, so the state, if the defense in this case, and based on the review of the evidence, kind of goes, hey, look, this case is coming back because we introduced those lyrics into this trial and it falls on all fours. Now, on Young Thug, given how long this trial is going to take, I don't anticipate either side to be like, yeah, judge, you got, you know, let's go ahead and do it again. No, we're going to take this bad boy up, you know. But that's it. I gave you a very long-winded explanation, but that's pretty much.
No, that's fine. Okay, so all that being said, so basically, in layman's terms, the motion to set aside verdict is a very good attempt to avoid having to appeal, assuming that it's ruled in your favor. Now, with that being said, what are the odds of, I don't know if you've seen it much in New York, because New York is a whole different animal. I'd say New York and LA and Chicago, they may as well be their own country when it comes to laws, when it comes to culture, cost of living, and everything else. But in your experience, and seeing this type of motion filed, what are, I guess, statistically speaking, the odds of a judge saying, and like you said, a lot of times the prosecution knows they screwed up. But this type of prosecution, they like being strong and wrong. And they are 10 toes down for being wrong. And it seems like it works in their favor. So in a less corrupt jurisdiction, what are the odds of, you know, like I said, I got to keep it a buck. In a less corrupt jurisdiction, what are the odds of a motion to set aside verdict being successful?
Since I still have a license in New York, I'll say, while not adopting or condoning your allegations of corruption, you are free to say what you want to say.
We can infer from decades, even centuries of history, that the New York City PD and DA are corrupt.
I hear you. I'll just simply say that I'm not even going to address that because they might say I didn't go far enough in addressing it or went too far. Who knows? I'm just going to say, moving on, you have the right to your opinion. I will say this. Is that the proper way? Whatever. Anyway, yeah, statistically, I will say when I was in New York, the one thing that I liked about New York, honestly, is that legal arguments, even ones that got down to minutia in criminal cases, did in fact carry the day. And I like that about New York. So I mean, I've seen arguments. When I was a prosecutor there, I had a case that got reversed. I didn't try it. I was in sex crimes, and they gave me a case that got reversed with a young lady who was had Down syndrome, who had been attacked by her bus driver, and that was the allegation. And when they asked her a question at trial or in preparation, they asked her, "Do you know this person?" And she said, "Yeah, he's my bus." Now the point was the defense didn't. I mean, the prosecution didn't divulge that information. It got reversed because they said, well, the jury could have considered her saying he's her bus as thinking that she described someone else. Now, obviously, no bus has attacked anybody. But,
right. She has Down syndrome. So you have to understand that that's her way of saying bus driver.
Exactly. But it got reversed. Now, in the case came to me. Now, of course, I didn't make it clear to him. I said, if we got to go to trial, I got to put this lady on the stand again. I'm going to tell you right now, I'm going to add some charge. I'm bringing everything that I got. So you can tell your client to take a deal or tell him and I hadn't lost the case at that point. And I'm like, I'm bringing everything. And he took a deal. So there you go. But but anyway, my point being is that New York, I like it that these arguments do have, I think, do carry some weight. And in this instance, the intentional assault and the reckless charges were inconsistent. That is, I think, that does carry merit. I also think that the fatal variance argument is significant, because if she's saying, I don't know when it happened, and the actions that she is saying.
You froze up again. Guys, check the chat. I put the link for the motion in the chat. Kirby, hold on. You're freezing up.
He punched me. And the jury, I don't know. I was trying to move it because my end froze. So I wasn't sure if y'all heard me.
Yeah. It froze at fatal variance argument is.
Okay. So as to the fatal variance, where they're saying that what was alleged was intentional and what was proven was intentional, and yet what he was convicted of was reckless, I do think that argument does carry some tremendous. I think that's a significant argument, because it is a fatal variance. You told me to come prepared to defend this, and then you convict me of that. And if the witness says she don't know how she got hurt at all, well, you really can't find me guilty of either one. Like, I don't know what happened. I know so you don't even know. So I do think that fatal variance is important. Also, the not charging of the justification charge is also important, because when she, I think, took the phone from him, that's a robbery. That's a theft. So she says, because her statement is she took it and she turned away. I will give you that. You took my phone and turned away from it, so I grabbed my phone back from you, as I can do. And the jury, no, that was it. Well, Judge, if the jury's going to now, because again, that could be the one area where, and follow me, that's where they are alleging the recklessness came from. As to the finger, you recklessly hurt her finger when you were getting your phone back. Okay, is that your claim? Because I need a justification charge, because I was doing something lawfully in response to her unlawful behavior, and that's when that occurred. And now we can evaluate whether what I did I excessively do this? Was I out of control? But the jury needs to have some framework upon which to evaluate that, and can't just say, well, he did take his phone from her and he broke her finger, so that was reckless. Well, let's put it in context. He took his phone from her while she was trying to recover an item that she had stolen. And so we have to get a justification charge so you can evaluate the use of force that he engaged in. So I think that those are those to me are great grounds. And while I don't know that the trial court in this instance, and I have never had in all the years I've done appeals, and I'll say this from the trial I did have, the murder case I just had in Savannah. It was actually a high profile case in Savannah too. But here's the funny part. The judge struck a juror, the lone holdout, the single holdout for not guilty. She removed that juror. Now, she believed she was right. Even after the appellate court said no, she still thinks she was right. But the point I'm making is that I've rarely had a judge to, after reflection and after having heard argument, do something and then turn around in a motion for new trial and go, yeah, I screwed that up. I've never had that. I've never seen that. What I usually see is, no, I see what I did. And at the best you can hope for is, I see where you're going with that, counsel, but whatever that line is you think I crossed, I didn't cross that line. Now, will I see a judge do it for something else that they weren't at fault for, or they really can't be attributable to them? I have seen that. But if it comes out to a straight up, you screwed up, you messed up, fix this, I have. And even when that's the reason that the conviction gets reversed, and I've had reversals, and that's been the reason, never once did the trial judge say, yeah, you were right, Mr. Clements. They were like, nope, you're wrong. On appeal, they go, nah, and they reverse it.
Okay.
Thus, I don't think the trial judge will do it, but I think the appellate court has a strong likelihood to do it.
Okay, so basically, I hate to even articulate this because I feel like I put it in the atmosphere, but so you're saying that the odds are kind of slim that this motion set aside will be successful?
I think the odds are slim that the motion for set aside, I think that there are some great grounds, and I don't know enough about the judge to know.
Right.
But if something comes out that suggests that the facts upon which the judge, or the arguments upon which the judge was relying, were faulty, then yes, meaning the judge might say, I made this ruling based on this specific representation that you gave me. And now after trial, I see now that that specific representation that you gave me didn't come to pass. Then I see the judge, because the judge is not saying he was wrong, that he or she was wrong. What the judge is saying is, you led me astray. And I don't have a problem correcting an error that I made because you led me astray. But if you say, I had all the facts and everything is as it was, and it still is today, and this was my decision, I have never seen a judge go, I went astray. I've not seen that. It can happen, but I've not seen it. You led me astray, you're going to get something at this level. I just made a mistake on my own, and I knew everything. That's for the higher court. That's just
the judge didn't make the mistake. The jury did, based on what the prosecution's, what is it, prima facie case, whatever they call it, was.
No, but that's what I'm trying to tell you. It's only on the jury charge. I'm using that to explain the jury charges and the submitting the intentional and the reckless charge. Those things involve legal decisions that ultimately the jury got to consider. Insofar as the jury is concerned, I want to say this, and I know how strongly you are on favor of Jonathan's side, but I have to say, to be completely,
I can be objective, okay? I've been doing good so far, right?
Right. Well, but let's be objective too. To be objective, we do got to look at the fact and all the other evidence that came in, and we have to say, unless that evidence should not have come in, and that's another issue. If that evidence shouldn't have come in, that's one thing.
That background information should not have come in, but you can beat that dead horse until it's dust.
Right. But what I'm saying, since it did come in, let's talk about it. And what I'm saying to you is that if there's a history of abuse and there's a history of
alleged,
well, you say alleged, but everything is alleged until the jury finds it. Let me say this: Charles Manson didn't kill nobody until he got convicted. You understand what I'm saying?
He still didn't kill anybody though, and I can't stand the man. And he's probably roasting in hell right now, soaked in gasoline. But he didn't kill anybody.
Well, he ordered them to, which is the same.
He persuaded people to, exactly.
Well, now, don't even get me started on that one, because I can go down the line on that one. But I will just say this. If the jury, considering all of that evidence, we'll just call that the date. The trial is the date, and the deliberation is the engagement, and the verdict is whether y'all get married or not. Is the marriage.
Please don't talk about that. But anyway, go ahead. Go with your
I'm just saying that everything on the date came in, and the jury got to consider that. And the jury got to say, we saw these same witnesses, and we got to hear them, observe them, and from our collective experience, and given the charge of law, and us not knowing either one of these people and having nothing really to do. These are just complete strangers to us. You say he's in a Marvel movie. I ain't never seen a Marvel movie. Yeah, I don't even know who this woman is. I have no idea what her claim to fame is. I don't know these people. But I've been called in, when I was supposed to be in work, and y'all gonna pay me whatever the going rate is, $15 a day for being on this jury. And I was on this jury. 40. Okay. So
they got some Christmas money for that 11 days, but go ahead.
Right. So I got $40 a day to sit and listen to some complete strangers tell me something, and doing the best I could do. I think he did it. It's hard to overcome that concept. That is the very basis of our jury system, which is, a lot of people can disagree, and there's a lot of reasons for that disagreement to exist. But we're going to put you in the courtroom, we're going to listen to the evidence, and we're going to let people that don't know you and have no bias for or against you sit there and decide what they think. And clearly, these jurors thought that this man did it. And there was some evidence. Let's just go with this. There was some evidence, even that, his call history, the whole, I'm going to do myself in or whatever. There was some evidence of some behaviors that you kind of get, I'll just call it disturbing. You're like, bro, that's what you do? Like really? That's how you get down? I'm just being honest.
Okay, but pause for a minute. I'm using pause in the wrong context, but I'm using it in the right context. Y'all are using it in a whole different context. Every last one of us, even you, Kirby, with minister parents, you know, having gone to a Christian undergraduate university, you know, damn near walking on water. We all have said and done some terrible, terrible things. I can't say I've done terrible things, but I've said some terrible things because my personality, I can go from 0 to 100. But I usually don't get to that point until I'm completely ready for you to be out of my life. I am very thoughtful in my approach to most things. I don't go off the deep end unless I'm totally ready for you to just leave my life, because I do think, you know, I do value certain relationships where I won't do that. But most of us have also not been recorded doing that. You understand what I'm saying? So I'm sure you've said some things at 34 years old that if somebody recorded you, you probably would not have the career you have now. I've said some things at 34 that if somebody recorded me and played it back, I wouldn't have even a family right now. You understand what I'm saying?
Right.
So, and in context, he didn't even say anything that was that terrible. I mean, what? Stop drinking, act like you got some sense. Okay, I use an analogy that people, you know, that let's say Gen Zers can't grasp because most of them don't read, can't write cursive, can't read an analog clock, but they can sit here and clown me about Martin Luther King and Coretta Scott King when there's at least 10 different rap songs that reference the same exact context as he put that conversation in, but nobody remembers that because half of them weren't born. And like I said, half of them could barely read. So it's like, you know, that was terrible. That was something that this dude's character and career should be based on. He wasn't cursing. He wasn't yelling. He wasn't calling anybody any names. He literally just was like, dude, fall back. You know, act like you got some sense. We've already discussed this. This was the plan. You're deviating from the plan. And so now I'm going to give you examples of women that did not deviate from the plan. What?
I got you. And I'm going to say this. Well, and I'm going to answer the question for you. You ask what makes it so terrible. And I say it's not about terrible, meaning you were terrible here, terrible here, terrible here, and therefore terrible here, because the law says that just shows propensity. And I can't bring out that you just are a terrible person and therefore you must be found guilty. It is about whether it is probative of the facts introduced. And one of the issues is, why did you not report X, Y, and Z? Why did you feel to do this? We got to get the context of the dynamics of the relationship. Now, some people might hear that same fact pattern and go, oh, that's fine to me. Others might hear that and go, that reminds me of my daddy and how my daddy treated my mom. And my mom couldn't go outside. And my dad told my mom, I need you to wear high heels around the house and wear pearls every day. So it can hearken to that. I'm just saying to you that you're
not supposed to have. My mom was a domestic violence victim. So I get it. I totally get it. But at the same time, if I go on a jury with that background knowledge of my own experience seeing and hearing those things, that's against the instructions. You're not supposed to use your own personal biases in making a decision on someone else's life. You understand? But it does, though. The judge literally says that.
No, but and here's the point, though. How you see the world is based on how you've seen the world throughout your existence. I don't know what it's like to grow up in a household with a domestic violence, period. I don't understand that. My parents didn't yell, scream, fight, none of that. And that's not how I grew up. So when people tell me, oh, when people start yelling, I get quiet because I don't want, and I'm like, I don't get that. That doesn't mean when they come to the jury, they suddenly have to function like Kirby, who is like, look, I quite honestly, I mean, I've had people joke about me. You know, even my own cousins will be like, man, you grew up like freaking like the Cosby Show, man.
Yeah, exactly.
I mean, and my house is like the Cosby Show itself, except I'm the lawyer. My wife is the lawyer.
Exactly. Right.
That's my life. So when I grew up watching the Cosby Show, when it was out, people would say that's not real black people's lives. I'm like, I'm living in a neighborhood with my next door neighbor. Both his parents are together. His mom's a teacher. His dad's an engineer. Up the street, preacher. Next door, ex-pro football player and ex-wife, doctor down the street. That was my existence. So I'm watching Cosby going, that's how I lived. That's how the people in my neighborhood lived. I saw upper, lower, middle class, and even poor black people with complete households, good times. I can understand good times. So we bring.
And I even had a complete household in the project. We lived in the project, but we had two parents, and both parents worked. But my dad got addicted to the booger sugar and started flying heads. But I mean, at the end of the day.
But you bring that situation, and you're not going to convict somebody because that person is doing what your dad did. But when you're looking,
I would never.
No, and no one is supposed to. But when they're looking at the evidence and they are having to process that evidence, what I might find absolutely unbelievable. I'll give you an example. We had a case in Georgia where I remember my friend, he's actually a neighbor of mine now. He was trying somebody for abuse, and the father had a drug problem, and they said he came in and took the food off the table, the plates that they were eating, and sold them. Now, I couldn't comprehend that. And I remember the big one was he sold half a stick of butter. And all I could think was this: who would buy a plate of food from a crackhead that's just like, you want to buy this? And who would buy half a stick of butter? That, if you told me that story, I would be like, that makes no sense at all to me. And it would be very difficult for me to believe that. But if you said, look, man, in my neighborhood, I can tell you in my life, that really did happen. And now I know it's happened, and I have that. I bring my life experience to the table. So the jurors bring their life experiences. They're supposed to leave behind their biases, but their life experience and how they process stuff, they keep that. And so you can process something that sounds ridiculous, i.e., he picked my plate up, went outside and said, who wants to buy this plate of food? And somebody paid for that plate of food. Up until that case happened in Fulton County, Georgia in the 1990s.
Yeah.
If you had told me that, I'd have been like, you lying. Nobody's eating a half-eaten plate.
Woo!
Nobody's buying half a stick of butter. But
you'd be surprised in the hood. I could totally see that happening in crack era New York City for sure.
Yeah, but see, that wasn't that's what I'm saying. The jurors they leave behind their biases, but they bring their life experiences. So if they're hearing that recording of Jonathan saying certain things, they probably could have flown. They probably could have taken that as well and been like, well, you know what? That does sound real controlling to me because I understand how controlling behavior works. And that is an era of control. You act like you're giving me good advice, but what you're really telling me is that I'm so far beneath a decent woman that only you can tell me how to behave. You are the Pygmalion to my Galatia, if you will. And so there you go.
No, Kirby, no. You've been married how many years? 30 or more?
32.
32. So I'm positive that when you met your wife, you guys had a discussion of however that looks, as to what you're a lawyer, she's a doctor, what your future would look like, how you wanted to raise your kids, how many kids you wanted to have, how far apart you wanted them to be, where you wanted them to go to school, all that. And I'm sure at some point, one of you deviated from the plan. What's her name? Suzette?
Yes, Suzette.
Deviated from the plan. And you were like, look, Suzette, or maybe she said it to you. Look, this is what we talked about. I'm generalizing, but I'm sure there was something that you guys agreed upon that somebody deviated from the plan. Somebody got a tape recorder now, because we're talking the early 90s now. Yeah. And we got those big tape recorders with the red record button.
Right.
Somebody's recording you talking to Suzette and saying, look, you said that we were going to have kids 3 years apart, and here you are pregnant again. Why didn't you take the birth control? And somebody could hear that in a jury trial and be like, damn, Kirby, like what? But in reality, that's fair, because only one of you can get pregnant. That's fair. We agreed that we would space these kids out 3 years apart, and you skipped a dose. Now we got kids back to back. We got 2 sets of diapers, 2 sets of formula, 2 daycare bills, you see what I'm saying? And now that's going to put us in a bind because we're not at the top of our respective professional games yet.
Or one could say, in that same scenario you just gave, Suzette could have equally have said, no, Kirby, what happened was you said you wanted kids 5 years apart. I said I wanted kids. And I said we can talk about that, but I do agree. I do agree. So because I tell you, I see a lot of relationships. I mean, that's the benefit of having parents in the ministry, and I hear people talk, and it just don't even know the stuff I've gone through and seen. Not gone through, but seen. And a lot of times, I it's like I'll use another example. I saw a guy. There was a guy who proposed to a woman, and she's like, no, but the no was like no, and then I got to find out this joker proposed all the time to all kind of women. He was proposing regularly. So I'm thinking, so he really doesn't look at what the other person is saying. He kind of says, goes on his own, and that's all in his head. And the other person's like, hey, I'm trying to tell you no. I'm trying to tell you we're not at that level. I'm trying to tell you we're not even dating. We just started dating. And you're like, baby, I think we should get married. He's like, she surprised me. She broke my heart. Like, how'd your heart get broke? So your heart got broke because you lived a world that ignored what she was saying. And you didn't pay attention to that. And that's what I'm saying. Jurors bring that to the table where they go, I know that and I know people who have agreed we're only going to have X number of kids, 1 child. Now you want 2. That wasn't the plan. I understand that. But the spectrum is we never said that through you said that and we never resolved that, or to, yeah, we actually agreed to that. And you're right. I'm just deviating from the plan. All of that's on the spectrum, and it's up to a jury to decide if that were the issue, where it was on the spectrum. Because you picked a side before the game. I think my team should win. We got to play that game. It's March Madness right now. I'm going to need to see the game.
Well, I need to see the brackets because I'm not feeling.
I heard you got a 7'2", Sarah 6'9". You might win. Yeah, I'm gonna bring in the basketball because it'll open up a whole other.
Yeah, right. We have to go into bracketology next.
Yeah.
Yeah, I don't know, Kurt. I don't know, and I think we need to get rid of the jury system. Then jury's got to go because clearly either that or they need to start or come up. And I know I'm being completely unrealistic. But they need to start qualifying what a qualified jury is, what a qualified jury consists of. Because right now we already know the jury system is designed to pick the not so smart people, and the people like us will never get picked because we think we're too analytical. We ask too many questions. We will cause a hung jury or some delay in reaching a verdict. And to me, sometimes that's the L you got to take to make sure justice is served, because there's a lot of people that come on these juries that just want to go home and ran out of excuses to not serve. And this is why we get verdicts like we get, because at the end of the day, whether I support Jonathan Majors or not, we can all agree that there was more than enough reasonable doubt for him to get fully acquitted, regardless of your personal experience, whether you like him or not, whether you understand the law or not. Everyone knows what reasonable doubt is. And there was many, not just one, at least 10 different instances of reasonable doubt. And that's all they needed to do was use that reasonable doubt and acquit. But instead, like you said, they're using Bill Cosby, they're using Archie Bunker, they're using James Evans as their background knowledge of trauma. And projecting that onto someone's life, and that's crazy.
You were right, because I will tell you, I wish the jury system was better. And we don't get to do. Wouldn't it be better if we just got access to people? They just ran it. We could do a background. They gave us a spit out of the jurors' social media posts. Because you tell me, hey, I can be fair and impartial. Well, funny thing, because I got a video. I saw your last several social media posts, all saying I can't stand men or Black men are violent or whatever.
And that's the world we're in now.
Yeah, and we have the ability to discover true biases of jurors, but we don't utilize that ability to discover those true biases. And we're basically in court still throwing chicken bones and tea leaves and going, "Are you telling me the truth?" "Yes, I am." "Oh, I believe you then." It's like, no, what are you talking about?
Right. Like, what's the point of having?
Yeah.
Right. And what's the point in having a voir dire if you're not going to actually do what you're supposed to do to ensure that you're not getting nuts and or man haters on the jury?
Oh, look, I can testify to the nuts because I tried a case where I had a nut who I offended him by making a comment about somebody being a mind reader, and come to find out he was a psychic, a professional psychic. And he told
how the hell are you on the jury? Like, what?
Well, it was my choices were between him or someone who had admitted mental health problems, who was exhibiting some strange behavior during the voir dire. When I'm talking to him, they kept looking at me and smiling, and I was like, "What's?"
You're like,
"Did y'all see this?" And then I was like, "No,
right.
I'll take this guy." And of course, that guy ended up being the guy who was offended because I used the word mind reader and said he could determine that the guy was not guilty because of how he swallowed. So I'm just telling you, you get all kind of crazy. If people want to know how the jury system works in America, let me just tell you this. Take your circle of friends, acquaintances, and family. Just take them all. The good from the best to the ones you'd be like, "God damn, they're going to be there."
Right. He can't come to the cookout. Yeah.
And know this, every one of them could be on a jury. Every single one could be on a jury, and not a single person out here would call the court and say, "Listen, my uncle's coming for jury duty. You don't want him on there. We're not going to do it."
If it was an option, if there was an option to call in and say, don't let Uncle Buck on that jury, I would do it, just because I see how that can affect people's lives. And and like you said, that example that you gave, your whole family, the good ones, the middle of the road ones, and the completely screwed up ones, the odds of the completely screwed up ones getting picked is higher. And that's the scary
part. Absolutely high, because they're gonna be on their best behavior in jury selection. Like, I know how to sit pretty.
Because they don't have nothing to lose. They probably
don't
not
answer any questions.
They don't want to go to work, so they'll take the little extra $40 plus whatever their job is paying them.
Yes.
And sit there and screw up your life, right?
And won't answer a question. They sit there. How many here have crazy views? They don't raise all the questions. Nope. I mean, I've asked jurors, "Well, man, you didn't answer any question. Tell me about yourself." And just like, those are the hardest ones to decide whether to get rid of or not, because you didn't give me a reason to keep you. You didn't give me a reason to get rid of you. Right. And now I kind of got to go. I know who I want to get rid of, so I got to take a gamble that you're not crazy.
And take the lesser.
Crazy they are. Right. Well, not all the time.
But right. And I mean, and again, the society we live in today, the likelihood of you getting a toxic feminist, someone with untreated mental illness, is very high. And that's who you get on the juries. Now, you have toxic feminist women and you have the men sympathizers. And those are the ones that you'll get on a jury that will do what they did. Not look at any of the reasonable doubt and just use creative license with their own personal experience, with evidence that wasn't even evidence, and everything else. Oh, we got 108 people in here viewing. So I got to say this little thing. If there's 108 of you in here, I better see 108 likes. I want you guys to share, like, follow. I tagged Kirby in the show notes. Follow his IG, follow his YouTube, and share. All right. So I'm going to let, so Kirby, we're going to segue into the response from the DA's office to the motion to set aside the verdict. And I'm going to bring in Lauren. Okay. All right, Lauren, you're in. Introduce yourself to Kirby, because Lauren is a media person. She was in the actual mainstream media for decades, and now she's doing her own thing. But she's going to introduce herself so you can know who she is, and just know that she's not somebody I just randomly threw in here. she's been delving a little deeper than I have too, because again, I'm just kind of got tunnel vision. I can't get too far deep down the rabbit hole, else I wouldn't get anything done. But she has more information about the prosecution's response to the motion to set aside verdict. I just kind of skimmed it. I saw it on Twitter with someone, I think it was Kat, posted a little snippet of what their response was, and it looked no different than what their prosecution was. They didn't add anything extra. They didn't, elaborate on anything. It just seems like they're reiterating what they already said during the trial. So that might help you as well, Kirby, give insight as to the odds of it being granted. But go ahead, Lauren, introduce yourself and give him some insight on what you know about the response to and that just came out last week, the response.
Yeah, I think so. Kirby, how you doing? It's great, great listening to you. Yeah, so I've been in the media for 20 years. I'm from New York. My mother's from Virginia, but I grew up in New York, and my father was a cop and a corrections officer in New York. And I have a relative who's a judge on Long Island. So I've got a bunch of cops in my family and sort of maybe more familiar than most with the way our system really works, but also having worked in big media, I've seen some things in the way that this is covered that are problematic, but we'll stick to the law for the sake of this conversation. And I have a few questions about some things that I'd love for you to clear up. First of which, are there any penalties in New York with regard to the prosecution, the Manhattan DA's office, or any DA's office in the 5 boroughs sharing information with the media on a case?
Ordinarily, and it's been a while, the rules of ethics and a lot of people's ethical rules will follow the ABA, American Bar Association's model rules on what prosecutors can say. And the general theme, unless New York has something more specific, is that there are limits on things that are really confidential and privileged. Like I can't just go giving you somebody's rap sheet because you can't talk about that. But if you can just glean that other stuff, I can tell you about that. The prosecution can certainly say the defendant has convictions for X, Y, and Z. The prosecution can share stuff, but in terms of offering opinions about the defendant's guilt or innocence, ordinarily you don't want to do anything that's going to taint the jury. So don't go around there, he's guilty as all get out. But you can certainly say we're confident that we can win this case.
Well,
but in terms of sharing evidence, I have to get more
specific. To be specific, can the DA's office, let's say allegedly the DA's office gave the media the testimony of Molyneux witnesses who may have appeared during the course of the trial to the DA's office, and let's say the judge ruled that the Molyneux witnesses could not be used, their testimony, of course, could not be used during trial. And let's say one of the assistant DAs decides, well, whatever, I'm going to give this to a reporter at the New York Times. Is that ethically, is there any issue, is there any rules of engagement with regard to lawyers or the DA's office that would make that a violation?
Answer is yes, and it depends. And what I mean by that, again, is I wasn't prepared for that specific question, but I'll say that's why I say it depends. Here we go. One, if on Molyneux, and just so people know, Molyneux is evidence that of other conduct that you did that you want to introduce to try to prove that this individual did this. It shows intent, course of conduct, motive. If the guy commits a robbery wearing a clown outfit and he's now accused of a robbery, we don't know who it is. And it's like, well, the guy who was robbing us was in a clown outfit. You can introduce the other stuff of this guy committing other robberies in a clown outfit to show that's his MO. That's how he does it. So that's the Molyneux evidence. And if there is Molyneux evidence, it can be disclosed. There's no privilege there. But if you're doing it to taint the jury and the jury hears about it because you've made extra or outside of the courtroom comments about it to taint the jury, that's going to be a problem. But the fact that people who did not decide this case know other dirt on the defendant thanks to the prosecutor, the defendant doesn't have a right to appeal anything here. That it didn't affect your trial. So it's just something that you did. If someone wants to file a complaint on the prosecutor who disclosed that, you can do that, but it has no impact on this particular trial. Unless you can link it and say it has an impact.
I get it. Okay, so that's fine. Okay, so the other thing is that, I mean, in my view, what the reaction of the prosecution was to Mr. Majors' attorney's motions, the reaction was a New York Times story that appeared 3 days later, perfectly timed right before what we thought would be the sentencing date. Mm-hmm. And in fact, the same thing has sort of happened again, to quote Pam, entertainment, we're seeing more stunts and shows with regard to certain things showing up in the media that are negative for Mr. Majors right at the time of sentencing, right at the time that Judge Gaffey has to make his decision with regard to these motions on April 1. It is hard to believe, and as someone who knows how media works, and in fact worked at ABC News on 77 West 66 once upon a time, it's hard for me to believe that these things are coincidental, though of course nobody can definitively prove that that's what's going on. But to get to another question here, I think that the reaction of the prosecution was the civil lawsuit that was filed on the 19th of March. The reason I say that is, of course, as you know, whatever is in a civil lawsuit is shielded from defamation. We have not heard from Ms. Jabari on any interview or anything else because, of course, that's not shielded from defamation. Her courtroom testimony is shielded from defamation, but what her lawyers filed on the 19th, the civil suit, has new, unheard, unproven allegations never before heard that I think it's hard to believe that the judge, Judge Gaffey, I mean, as a human being, I know he says, and I'd heard him say in court, I sat on the case, nowhere near as long as Danny. I was only in there for 3 or 4 days, but certainly heard the judge say that, oh my goodness, jury, you can't listen to anything else other than what goes on in this courtroom. I think as human beings, we know that is all but impossible in the media world we live in. So what just happened was a civil suit is filed on March 19. Everyone sees that, including probably the judge who is about to rule on said motions and, of course, the sentencing, if in fact he gets to that, which I think he will. I just would say that, we live in the real world, and in the real world, when the courtroom that I saw with all white members of the media and an almost all white jury, one black person of which they tried to throw off the jury. It seems to me that Mr. Majors had no chance in this matter, okay, because we're at sort of this moment with regard to Me Too in particular, where due process and presumption of innocence are openly being challenged. So I think that, I guess my question for you is, what was your experience in New York with regard to judges, ignoring what they saw in the media? I mean, I can't imagine that he doesn't see or did not see that story that just dropped on. The Judge Gaffey did not see that, and I think that would influence his decision making. But what you tell me, I mean, obviously you know more about New York judges than I do, but I just would ask you that.
And before you answer, Kirby, really quickly, just to give some insight as to why she's asking that question as well. I was there 10 of the 11 days. And then someone stood in for me for one day that I wasn't there. And he was basically able to verify everything I had been saying prior. I feel like when the momentum picked up with a lot of us, well, I wasn't a content creator at that point. I was just kind of like doing what you do, joining someone else on their stream. But once the content creation started picking up, I noticed a change in his tolerance for the defense. The first 5 days, he was really fair. Like, I was like, wow, this judge he's on point. Like, he was fair to both sides. He, when he allowed certain things in and didn't allow certain things in, I was like, I can rock with that. I see what you mean. I got where you're going with that. I understand. But by the second week, it was almost all pro prosecution. He was just allowing stuff in that I was like, well, what? And he even had to think about it because he would pause. He would pause and he'll be like, that is leading, but I'll allow it. What? Last week you wouldn't have allowed that. So that's where I'm just giving you context to what she's saying. So no, go ahead, answer. I'm sorry. I hope your ADD
right. No. Look, I tell you, it's fine with me because my mind is racing on this one. I will say the following. It's a very complicated response because, and work with me on this. Number one, in society right now, we got people picketing judges' houses all the time. People picketing the Supreme Courts. Hey, we don't like your decision on that overturned Roe versus Wade. We don't like your decision on this. So we have people all the time exerting pressure on judges, and everyone thinks it's acceptable when it's exerting pressure to achieve the result that they want. But then when they get a result that they don't want, they'll go, well, that judge was corrupted. And I'm like, well, not you. I'm not accusing you of that, you all of that. I'm just saying just overall society. So what we see is when people say that judge was influenced, it's like, no, not you all, but people are usually upset that the judge was influenced or they believe the judge was influenced contrary to what they wanted, but they would be perfectly happy if the judge had been influenced in their favor. So it's sort of a dangerous game that people play, which is to go out there and try to influence judges by picketing and protesting and then saying, but when it's an issue I care about, no one should you should not rely on that influence. So that's a double hit. That's a little, I'll just say public hypocrisy. Secondly, judges are not immune from hearing this information. I mean, there's just no way, because you're reading the court decisions, just judicial decisions, you're going to work. The judge they don't have to secret themselves from the press or they don't got to. It's like, look, I'm here to rule and do whatever I do. They don't have to secret them, and they have the benefit of it being a jury. Now, if it's a bench trial, the judge might be a little more different. Like, I'm going to be very cautious about what I hear. So can that influence a judge? I can't say no, because I don't know. I mean, I think anything that you hear in public that's focused on what you're doing is going to have some impact, even if it's just the impact of you thought about it. I thought about it, I considered it, and I've disregarded it. Well, you know what? You took however long you took to think about it. And so that is some degree of influence. And maybe you reacted the opposite direction. So can it influence a judge? Yes. But have I seen it influence a judge to the level that I would say you just became ridiculous and we're more concerned with your public image and wanted to absorb the public? No, I've never seen that. I just haven't seen it.
Okay, I hear that. Now, but attached to that question is this. Isn't the judge and the prosecution's office, aren't these people, don't they know each other? They're working in concert, correct?
They're in the same building. The DA's office is in the if I'm not mistaken, is it the 4th floor? It's in the same building as the actual.
I mean, in the same way that the cops work with the prosecutors, aren't the judges friendly with the prosecution? I mean, are we to think that these people are completely separate in terms of?
They're not in that building, Lauren.
Well, I'm going to say the following, and this addresses that concern. When I was in New York, and it's actually true even here in Georgia, I've seen it here in Georgia. The judge, you got defense lawyers who are just regularly there. So the judge is going to know the defense counsel. Hey, I mean, we're sitting here. I see you every week. So they're going to know everybody. Now, with the prosecution, there's battles over standards and goals when I was in New York, which is how long has the case been on the court's docket, and are you all moving? So there's conversation there. There can be acrimony or whatever. But what it really boils down to is this, something I was told when I was in the DA's office in New York, trying a case in front of a particular judge. And and my bosses told me the following. They said, this judge is good for the people, so don't piss him off. What that just meant is this is a judge that's basically good for us. If the ruling can go left, defense, or right, prosecution, they're probably going to go more prosecution. They're good for us. And when I was in Georgia, we know who the when you say pro-prosecution, I'll put it this way. We know who the judges are that are going to see things the way the prosecution sees them and analyze it. We just know that. But when I was in New York as well, less here in Georgia, a lot in New York, there were judges who we also knew were pro-defense judges. Like this, I mean, we had judges, there was a judge who covered her eyes. Don't show me that. And the lawyer and the prosecutor was trying to show them the law book. And they're like, I don't want to see that. And I'm like, oh, that's crazy. So judges bring whatever biases to the table that they have. Just because you know a lawyer, are friendly with the lawyer, or work with the lawyer, the fact remains that other lawyers are there and other people be gunning for you. There's a lot of other forces there that are looking to see what's going on. It's like, hey, I realize that you and this lawyer are always together. So it's just like any other human relationship. So I will say this. You have judges who are observably, from the prosecution's perspective, good for them, whether the judge intends to be that or not. But they just happen to be. And when I was a prosecutor in Georgia, I've told people before, you come to me with a case and you've told me, look, this is why the police were improper. I have said these words as a prosecutor. My judge isn't going to suppress that.
Okay.
My judge is not I know the outcome already.
The reason I asked that is that there were a number of things I saw in the courtroom that had me thinking that Judge Gaffey was leaning with the prosecution, unquestionably. I mean, I'll give you just one example. We had a New York City police detective who processed the arrest of Mr. Majors' accuser, Ms. Jabari. He shows up in court with his case file, which is huge. The judge, part of that case file was pictures of injuries Mr. Majors had on his face and arm that allegedly were caused by Ms. Jabari. And there's a good reason to believe, given the video that we saw, part of which was not admissible, which was Ms. Jabari chasing Mr. Majors block after block through the streets of New York City on the night in question. But those pictures were never admissible because the judge did not want the jury to see them, and in fact told the police detective sitting on the stand to cover them up. Okay, so I mean, there were many moments there where the judge was granting almost every objection from the prosecution, and in fact, I think threw off the defense of Mr. Majors. I mean, I think it's not, if you walk into that courtroom as a defense attorney for your client, you have a certain set of questions and a certain line of questions, and that is completely broken up by the judge. And of course, the judge is ruling in favor of the prosecution over and over and over again. I don't see how you really can present a case, but I will just say that I will be absolutely shocked if this judge grants this motion from Priya Chaudhry. I mean, I just cannot imagine that happening. So I guess that brings me to this question, which is there an appeal after sentencing? So if, let's say, the motion is denied, the motions are denied, we get to sentencing on April 8th, does Mr. Majors have an appeal? He has an appeal after that, right? Does he have an appeal opportunity? Is that correct?
Yes, he has an appeal opportunity. You can just do a direct appeal. There's two types. You can do the direct appeal. I got convicted. They file, they go and get sentenced, and they just appeal once the conviction is done. Now, they can also do what they've done, which is sort of like an interim stage. It just gives the trial judge an opportunity to fix the errors. And then if not, you go on off an appeal. But he's not giving up his right to appeal by doing this.
And Danny, was it accurate that the video of Mr. Majors being chased down the street by Ms. Jabari, that was not admissible, was it? Was that admissible?
Oh, no, that was played several times.
So if that was played several times, I wasn't there the days it was played. Part of my exasperation, Mr. Clements, is that there is a video of the defendant, as you probably have seen, being chased down the street by Ms. Jabari on an evening where that defendant spent his night at a hotel room 70 blocks away rather than spend it at his residence to stay away from her. She spends the night at a club on his credit card. Now, some of this was admissible, some of it was not, but as Danny just said, the chase down the street was admissible. So there's a point.
The whole thing, when he was trying to get her back in the car, when she was fighting him, when he helps her get out of the car, walks her the street, she's yanking at him. Every possible video, because they had car 1, car 2, and car 3. Yeah. Every version of that event in different points of view, zoomed in, zoomed out.
They also had the testimony of the driver who said, now there was some translation issues, but effectively the driver said to make a long story short, the woman did everything, the boy did nothing. He was trying to get away from her. So it gets to a point in the case where you almost had to say to yourself, have these people suspended all, belief in facts and evidence? Because the evidence was so clearly in the direction of Mr. Majors. And yet, no matter what happened up there, no matter what's shown up there, and no matter who says what, everyone is like operating on this idea that we all have to ignore it. And I can only tell you that as somebody who's a student of Ida Wells, to me, the thing was a throwback to not even the late 1800s, but like it just was on the level of you just have to suspend all logic, So I do think that, and you probably know, Mr. Clements, that this case started out with a bunch of charges that were dropped. There was a bunch of charges that they had in the beginning that they, of course, dropped because they can't prove any of this stuff in court. They could barely prove what they had, which is why we started getting into court of public opinion and, in the New York Times and Rolling Stone, because they really, I think, really did not have a factual case in court. So they started throwing stuff out into the court of public opinion.
Mhm.
And it worked. I think it worked for them.
Well, and I'll say this, even as to the exclusion of evidence, we kind of got to work through why evidence is excluded. And without opining on the particulars, I'll just go through this process.
Mm-hmm.
There's relevance, which is that the evidence it's probative. This evidence is relevant because it's probative of the issue, the fact in question. Then there's collateral. This is something that it's running alongside the evidence here, but it's not or side the case, but it has nothing to do really. It doesn't make this more or less likely. It's just collateral. Collateral stuff is excluded. Then we have when it's probative and relevant, then there's a prejudice component. Does the prejudicial value outweigh the probity? This is important, but it's so prejudicial that the jury would take it to a level or an extreme or misuse it for beyond what it's intended. Therefore, because of the prejudicial effect, now prejudicial is not the same as proves you guilty, because obviously proving you guilty is what the goal of evidence is, but there's something inflammatory, if you will, or triggering about this evidence that.
Yeah, Kirby, all that background knowledge for the first 2 days.
What that's what I'm saying. That's a good grounds for appeal, is because it becomes, did you convict him based on this stuff was admitted to prove a specific point, or did you end up just basically saying this guy is just a bad guy and we don't like bad people, and it's his propensity, and that would then allow a reversal. Again, in that murder case I was talking about earlier, another grounds that the court was going to reverse it is because they introduced some prior stuff my client had done, but they introduced it for like 3 or 4 different reasons, and the court said it wasn't admissible for 3 of those 4 reasons. It was only admissible for 1 of those reasons, and thus the jury got to consider it for other things, and it was improper. So now back to the court. So that's on the issue of evidence. Relevant, probative, prejudice not outweighed by the probity, and it's not collateral, then that's what comes in. Now, some stuff might bear upon, like, hey, this kind of helps you understand, but the trial judge has discretion on what to exclude. And so you kind of exclude it. But as a trial attorney, when you go there, you got to know that like this stuff is going to come in, not because I want it in, not because I need it in, but because legitimately this just has to come in. Now, the stuff that you want in that is a question because of the probity, the prejudice, that component, well, don't build your case. You got a whole bunch of questions about that, but maybe you can't introduce those photos, but maybe you can talk about it. Maybe you can't introduce that. So there are workarounds at all times. And then sometimes you just got to know, I just got to deal with what I got to deal with. Right. And we have here the one point with all of the inconsistencies, and I hear what everybody's saying. The thing that I learned this as a sex crimes prosecutor in New York, and I was ridiculously successful as a sex crime. I think I lost 1 case. That was it. And that one, even the judge was like, I don't know how you lost that. I'm like, I do, but it was based on juror bias. It was juror prejudice against my clients, against the victim's sexuality. But anyway, but in this instance, but the point being that when the testimony of 1 witness is sufficient to prove a fact. So you can have 50 people saying that he didn't do it, and here are the reasons he didn't do it, and here's why he didn't do it. And you can have a video that shows some things, but the video didn't capture some things that are inside that car. And the witness says, I'm telling you what happened in that car. And the jury, and they got the driver. Well, I didn't see that. Well, you also looking straight ahead, weren't you? Yeah, you didn't look in the back. So the jury can still say, but even if the driver says, I saw, it didn't happen. She says, I was there and it did happen. If her testimony is believed and satisfies all the elements of the crime, a jury can convict. And I've convicted people on 1 witness cases before. And it's just, if y'all believe this, I mean, I literally a crack addicted prostitute on the sidewalk. And that sounds ridiculous, but I won that. So my point to you is that if the jury believes that 1 person, independent of all the stuff that we said the judge did wrong or whatever, if the jury just goes, we looked, we listened, we watched, and having considered it all, we are satisfied. It doesn't matter. It's 1 witness. And then you go to, was evidence introduced improperly that affected the jury? Was evidence excluded that prevented the jury from getting a full picture, improperly excluded?
Right.
Or was the charge of the law faulty? Those are why you once you move beyond the sufficiency of evidence point. So that's what I'm saying, because no one is entitled to an error-free trial.
Okay.
You're just entitled to a trial that does not have errors that substantially affect the outcome.
Okay, I get it. Now, can you just shed some light on the question of how many cases have you seen a misdemeanor assault case, right? So we have a misdemeanor assault case. How many of those did you see go to full-blown trial when you were in the New York system? Is that unusual? Am I wrong to think that that's unusual?
Everybody said it was unusual. Even the judge said it was unusual.
In criminal court, I mean, I saw them go to trial, but a lot of times you work out I will phrase it this way. I think that the nature of this case was such that it might have been more difficult depending on the offer that it was made to him before trial. And that's the thing I want to hang on. If Mr. Majors was made an offer for a disposition equal to other people similarly situated and he turned it down, then yeah, that trial was going to happen. But like ID, they could have said, we'll give you an ACD, and a conditional discharge. We'll give you a B misdemeanor. We'll give you some other option. You go work it off and then we'll dismiss. If he was offered those and turned them down, then yeah, we were going to have a trial because you didn't take a deal. So our options at this point are plea or dismiss. But if they never offered him those dispositions, which if he took, and in his estimation the downside of taking them would not have, in other words, I'd rather take this deal and deal with the fallout of me taking this favorable deal.
But someone in the chat pointed out, and this should be pointed out, he was apparently not offered a plea deal at all.
That is unusual. And that's the point I'm making, is that's why I said if they did not offer to him the thing that they offered to other people and similarly situated people, then you kind of got to go, well, what's going on there? Because at that point, you begin to kind of go, well, so you didn't offer him what effectively we call here in Georgia pretrial diversion. Like if you go complete some classes and do X, Y, and Z and keep your nose clean, we'll let it go. Or if you do this, we'll reduce it and you'll get a conditional discharge. So long as if they didn't offer him any of that, and those things are what they offered similarly situated defendants, then you kind of got to go, all right, I see what y'all did here. And that definitely does happen, because not every time, and I will say this, and if you want my empirical data, I didn't keep all the numbers, but I'll just tell you, there are plenty of times when people of color are not offered the same deal that other people get offered or treated more harshly. It's like, well, man, why'd you go to trial? Well, if you offered me the same thing that guy got. I mean, there was a study out of Florida where they did a straight apples to apples, oranges to oranges comparison of plea recommendations and sentencing of black defendants and white defendants. And they were like, it was unbelievable. Equally situated, same record, same whatever, were not being offered the same thing. Now, no one's ever done any more studies since that time, which I don't understand how that's possible. Like, I mean, HBCU, get a grant, study these things. The government, get a grant and just tell us. But nothing has ever happened to follow up on that. But I know, and I got plenty of criminal defense attorney friends that will sit here and tell you, yeah, there are plenty of times where the black man is not getting offered the same deal as the non-black man. And as a result, you get forced over here like, well, he should have taken the deal. You didn't offer me a deal. And if he was not offered a deal, that's the problem.
In reference to the question that's on the screen, apparently when Mr. Bari was brought in to be booked effectively, there was this understanding that she would not be prosecuted by the Manhattan DA's office. And in fact, they were so bold as to say in the media, her attorney, Mr. Bari's attorney, was so bold to say in the media as this was happening, which was October 25 or 26 of 2023, she will definitely not be prosecuted. The DA's office told us that she's definitely not going to be prosecuted. This is all, this is no big deal. Effectively talking to the media. This is no big deal. How improper is that? It was almost like the New York City Police Department was told, though they made this arrest for assault on Mr. Bari, they were apparently told by the prosecutors right away, within 24 hours, we're not prosecuting that. Is that something you've ever heard of?
Yes, it is. And I will, but not for the reasons that they've said. Well,
Okay.
let me put it this way. Sometimes prosecutors will say this is a retaliatory indictment. That is, this indictment was issued in retaliation by I'm sorry, reaching down for something else. I'm sorry. The prosecution is basically saying, look, this defendant got arrested. And so what they went and did is they went and took out a warrant against the victim. And that warrant was retaliatory. It had nothing to do with the facts. The victim didn't do anything. The defendant just made it up. And that's a retaliatory type warrant. And that's just based on that testimony alone. But there are times when you go, well, there are cross complaints, meaning, yeah, you committed a crime against this person, and this person also committed a crime against you. At which point they bring both of those cases to trial. Now, what ends up happening sometimes is that there'll be a mutual dismissal because they'll say each side is invoking their Fifth Amendment right. In this case, what the prosecution has done is they said this case lacked prosecutorial merit, which in and of itself, that phrase bothers me because it's basically saying, we think this case lacks merit to us. And I'm like, okay, that's different. Don't you? Because the woman admitted the conduct, as I understand it, during her testimony. So, because I think she acknowledged previously that she had struck him, that she had hit him. And so she went through and everything that they're saying lacked prosecutorial merit, she is admitting, confessing to. So I've never had the prosecutor say that this case lacks merit when the witness or the person who would be accused confesses freely. And in this instance, she confessed freely in court, although that might be something they can't use her trial testimony against her to convict her. But the fact of the matter is, she said it. Thus, you know that the prosecution made a preference in this case. And the question becomes, why would they make a preference in this case? And why, as I said before, I was on your program, why would you, the prosecutor, say that that case is trash when it was made by the same police department that brought this case against Mr. Majors? So you're trying to tell me that your police make trash decisions because they know the whole thing. They know the whole story. If anybody knows what's going on, according to the prosecutor, these are the ones that know what's going on. And they just made a preference, plain and simple, because she acknowledged what she did, which is why on the lawsuit, I think she's going to have some problems. But still, she acknowledged what she did. So we already see that the prosecutor made a preference, and I don't find a legitimate basis for them to have made that preference.
All right. My last question. My last question, and then I'll bounce. The last thing sort of related to that is that there is a group in New York that helps women who are victims of domestic violence. For all we know, doing the Lord's work and all that. But the leader of that group is connected to the Manhattan DA's office, a former judge. The Manhattan DA, Alvin Bragg, has a advisory council. And this woman who has that group is on that advisory council attached to the Manhattan DA's office. Well, it turns out that an attorney in that group was Miss Jabari's attorney on this case. Do you view that as a conflict of interest?
I don't think, because DAs know a lot of people, and I don't see it as a conflict of interest necessarily, but I would certainly say that if they thought it really was a legitimate conflict, then they probably should have filed that motion. They should have adopted Donald Trump's position. I'm moving to recuse you. I'm going to raise this, and even if it doesn't get granted, I want everybody to hear it. I want everybody to know it because I'm just now learning that from you right now, and because that obviously wasn't really in the news prominently or featured. So, is it a conflict? It might present the appearance of impropriety. I'll go with that. I'm going to
make a video on it and I'll send it to you so that you can see what I'm talking about. I just noticed it the other day. It may or may not be a conflict. I do think that part of what's going on is that because they're working on an issue that is important to a lot of people, as well as should be, domestic violence, they're sort of shielded in sympathy by a lot of the moves that they make. No one questions it. I also think, quite frankly, that the media, particularly the New York Times, has a history of never seeing these cases from the angle of the defendant, particularly if that defendant is a Black male. There is no history for that at the New York Times. So so a lot of these facts that nobody knows about never get reported on because there's nobody in the New York Times newsroom apparently that thinks about the other side, the defendant's side of these cases. So it's a little bit complicated, but it's also rooted in our history.
Mm-hmm.
Oh, agreed. I mean, but understand this: nobody in the history of history has ever been condemned for being perceived as crime, even if it's in the pre-adjudication phase. Meaning, it's easier to say, hang them, burn them, they're bad people. You'll never get bad press for saying that. But if you say, well, hold on now, let's be fair, let's look at this, we'll also consider this. Oh, you think it's okay to beat women? I didn't say that at all. This man hadn't been accused. This man's been accused, but he hadn't been convicted. So the question is, did he do it? As I like to say, not every defendant is guilty of the crime that they're charged, and not every victim that claims to be a victim is in fact a victim, nor are they a victim of that defendant, nor are they a victim of the crimes that they allege that defendant did. All of those things are open, but nobody gets good press when you pitch that. And if you're going to come out in support of the big, muscular, strong-looking black man who's accused of a crime of violence against a white woman, let's just go small woman. That's never going to go. No one's ever going to say that. They're going to be like, oh no, look at him. Look at how he's on it. He's huge. He would have hurt. And it's like, wait. So you're making it all seem like you've already determined she's a victim, and look at how evil it is. Beauty and the Beast, if you will. He's the beast. But no one has ever lost for calling the defendant the beast. Flip side is half of all women in America that are killed by current or former romantic partners.
Totally understood. And I think that's why, I totally get the fact that when we look at the statistics generally,
this wasn't it.
We see the general pattern that is obvious to everybody. It's mostly men on the violent side of domestic violence. It's mostly women who are on the victim side. That is totally true. But I think they're using that for every case as this template on every single case. And in fact, they had two other cases of two other black men that happened in 2023, which was Kevin Porter and Adam Foss, where they effectively put that template on, regardless of the facts of the case. At some point, people have to pay attention to the facts of the case. The Innocence Project exists for a reason. So, the Innocence Project, with these black guys walking out of jail every week after 40 years of being in jail innocent, is the problem with this idea that you can just automatically assume that everybody's guilty based on the general stats. And I'll just say this lastly, the general stats were used in court with regard to testimony on domestic violence from a woman that the prosecution had testified, domestic violence expert, all good. She gave her very general testimony. She had no relationship with Mr. Majors or Mr. Bari. She gave general testimony on domestic violence, all of which was fine and accurate. Why I would say that if you're going to do that and allow that testimony, which of course the defense objected to, and of course the judge overruled their objections, then why can't we have testimony on the history of racism in New York? Why can't we have testimony that talks about Amadou Diallo and Eric Garner getting killed by the police? You can play that both sides, but what I find is we only play one side of that history, and that is for whoever looks like the staff of Alvin Bragg, who apparently doesn't look anything like him. He apparently is the only black person in the office that I can find. But when it's Black history, all of a sudden nobody can talk about it. So your point is well taken with regard to domestic violence. But I do think Mr. Majors is being used. This case is being used. It's a misdemeanor assault case that is in full-blown 2 weeks of trial with no plea offer. I would love to see the stats on how many times nobody gets a plea offer, a first-time offender with no priors.
Don't get me started.
So you found somebody more passionate than me, Kirby, so you could stop teasing me for being so my boy.
Kirby is frozen, baby. He's frozen.
Kirby, he froze on us.
He's frozen.
I think you can hear us. We just can't hear him.
In Hollywood.
He's coming back. Here he comes.
Hold on, Kirby. It's glitching.
Yeah, no, we were glitching. No, what I was saying is I talked about it before when I talked about those actors who were convicted of in some instances racial violence, and against people, but the angle that the media gives them is always a favorable angle or it's like, well, we're looking at this, hey, just it's like, oh, so you can now have perspective, but you're right. There's never any perspective on I've never seen. There might be, so I can say this: I've never seen perspective on allegation on any black defendant. Period. I've never seen
right.
anything.
I mean, it's like our history is invisible. Like, so African American history is invisible, but we had somebody on the stand who's a white woman, domestic violence expert. And look, domestic violence, of course, impacts all groups. I think, frankly, that should be focused on, right? But let's pick the cases where it's actually happening, right? I mean, I don't understand.
Right.
I think Mr. Majors' case was picked because he's a Hollywood actor. They knew that the thing would be in the media. It's just like the Kevin Porter. Yeah.
Not so even, I want to say, because the incident happened a year ago tomorrow. That entire month of March, he was on a media blitz. He had two box office hit movies released, and you had the Oscars, all within a 3-week span prior to the incident. This was ripe for the picking.
Right.
I swear to you, when I saw that news report happen, I was like, oh, I just went to go see Creed. How did this happen? I'm like, not you, Jonathan. And I wasn't even vested in him at that point. What got me vested in the process was the minute I heard that he was the one that called the police. And then my wheels started turning. So I'm like, how did he end up arrested? I will say, and I say again, and I have witnesses to attest to the fact. I did not even know his name when Creed came out. I literally told my daughters, I said, that's the dude from Lovecraft Country. Didn't even know his name. And I said, and I think that's the dude from The Harder They Fall. So I was not invested in him or this at all until I heard that he called the police about a week or so after the arrest. And I was like, whoa. So then I started thinking like, okay, something's off. Because if he called the police, why did he end up with the charges? And then that's when the wheels started turning, and I was like, okay, this is not right. Still wasn't even intending on going to the trial. Only reason why I went, and I'll repeat this story again, is because Flavio, who's actually doing the research on this organization that Lauren mentioned, kept pushing me to watch content creators talk about this situation. And I said, well, maybe I should go to the trial and see what's really going on. And they called my bluff. And I'm like the type of person, I'll keep my word, especially if I have the time and the resources to do so. And I totally was not planning on sitting through the trial. I was planning on going home after the first week and just coming back for the verdict. And then once I saw the rabbit hole we were getting into, I said, this is not right. And so that's why we're here today.
Yeah, I can top you on that. I've never seen any of Jonathan's movies, not even Creed 3, which I really want to see. I've never seen him in a movie. I've never seen him act. I just think it's outrageous. I mean, the more, and I've sat in on a lot of federal court cases where you hear all this stuff in the media, then you get in the courtroom and it's completely different. But this case is a throwback, an absolute throwback to probably, I'd say, the early 1900s. I mean, I was a history major, so I'm a little familiar with, trial history. I mean, this thing is, the evidence is in the opposite direction of what we're seeing happening. It just makes no sense. And, I just think we get to a point, even though we know what the reality is as Black people in America and all that, we get to a point where we have to not be silent about outrageous things that we see. We just can't just be okay with it. I mean, I just can't. I mean, so I'm just telling you that what I saw in the courtroom and what I've read was completely out of whack with what was being reported in the media. And that's part of the problem. Like, so people are under this impression based on what they have, of course, seen in the New York Times, the so-called paper of record. But then when you go deeper, say that like Danny and Kat have been doing, that is when you understand that, wow, there's a little bit more to this story, a lot more to this story, I would say. But anyway, thank you, Mr. Clements, for taking question after question. Thank you, Danny.
Right. You were supposed to be letting us know what the motion, the DA's response was, but it turned into an interview. Look at that, Kirby.
The DA's response, that's like a Cat thing. Cat would be a lot better at that than I would.
Cat, if you can come in for a few minutes, because we're already like 2 hours in, and I'm sure Kirby's wife is looking at him like, oh yeah, it's dinner time, boo, on a Sunday.
Yeah, you see me looking over there. It's like, we're supposed to go to the store. I'm like, give me 1 minute.
Okay,
even my granddaughter has called now.
We almost done, Suzette. We so sorry, but your husband is gold here. I tried to get him on earlier, but
man, you're great. You're great. Where are you practicing? You're practicing in Georgia?
Yeah, I'm in Georgia.
That's great. It's great.
Yeah.
It's really
but I'm
good,
going to tell y'all something on that press bias. I just never had the time to do it. I would love for somebody to, even with the New York Times or whatever, to just do a comparison of stories that they covered with similarly situated people and just show how they report it and the language that they use. Just take it and be like, look at it, because sometimes it's just a spin. They might use a word, like they might say both of these defendants are accused, but they might say one is allegedly, the other one is like, he said you have. And it's like, oh, so you got allegedly, and then, but one seems a little more credible. I'm just saying, I noticed the language. I comment on certain newspapers that I have on, I get the apps on my phone, and I always comment to them, like if they don't put a picture of a suspect, I immediately know what that suspect is not. I'm like, all right, you put up something, but you have no photo. I'll put on there, why don't y'all have the photo? And I said, I know why, because I know how they're going to look. But I would love somebody to just break it down, show them, and because the only way to make them back up or change is to hit them. It's to hit them where it counts.
You're right.
I think, and it's just like I'm not even fighting y'all in general. Every time you cross the line, I'm gonna point it out. I'm gonna show you, and I'm gonna make you defend yourself. Because if you want to be the paper of record, you got to be the paper of right record, not just the record because you say it.
I'm working on it.
That's not it.
Great idea. I'm working on it.
All right, let's work on it. Let's do it.
Absolutely. So I'm gonna bounce, and thanks a lot, Mr. Clements. Really, you're excellent.
Thank you.
We love you. See, we only get you every few weeks, and then we got to hold you.
It's great.
So Suzette, I love you too, but you might have to go to Publix by yourself because we ain't done yet.
Yeah, I mean, your analysis is excellent.
You got to make that Publix run dolo, my girl.
I mean, I work with a bunch of attorneys, but I've not worked. My attorneys that I work with, I can't get them to read this case. So I'm glad that you've paid attention to it, and I'm glad that you practice in New York. My friends all are in DC and Virginia, so it's a little different. But anyway, thank you so much, Danny. I'll talk to you soon. Text me if you need anything.
Text me because we should definitely do that. Kirby, I'm just real quick because
chat. See you later.
If you got any insight on the response to the motion, really quick, hop in. I sent you the link in Twitter. Kirby, we're done on the motion, but people did have a quick question about the civil suit that was filed. I did text you that happened like last week. Because obviously she knows that this decision has to be made next week on that the motion to set aside. So real quick, I'm going to share the screen on the the article. The civil lawsuit was filed last Tuesday in the federal courts in the Southern District of New York. In addition to the New York incident that led to Majors' conviction, Jabari alleges that he was physically violent toward her during incidents in Los Angeles and London as well. So she's basically giving context to those text messages that were admitted despite the Molyneux ruling. They were let in because I wasn't there that day. That was the one day I did not go to court. And apparently the defense said something that triggered the judge allowing those text messages in. So she's giving context to those text messages now. The one about where she says she was just going to tell the ER that she hurt her head. She's trying to say it happened because he slammed her head on some marble, yada, yada, yada. Off that. I'm going to show you now where, TMZ asked him about that.
Last question. I mean, I know your ex is, filed another lawsuit against you. I mean, how have you been? Another one? Yeah. I mean,
I'm not surprised.
You're not surprised?
I knew it was coming from the beginning, really.
Okay. I mean, how do you feel about it? I mean, I'm sure you're ready to put this all behind you.
I am ready to put it behind me. I can't say much else about it, though.
Okay.
That's the law.
Of course. All right. Well, thank you so much.
Okay.
All right. And then real quick, I'm going to play where you yourself said that he should file this. And now I want to know in context, should it have been done before or after her? I feel like, I don't know. Again, I'm not a lawyer. I don't know how to strategize these things. I'm just sitting here running off at the mouth. But I personally feel like he should have beat her to the punch, because it seems like everything he does now is going to be viewed as retaliatory, especially after what happened with the filing charges against her for hurting him. They viewed it as retaliatory, and that's why they did not charge and try her. But this is you speaking about 6 to 8 weeks, no, longer than that, January 15th, about what you suggested he do in terms of his own civil suit.
I think that, and that's why I say he should sue her anyway for the abuse that happened beforehand. Because even if you,
he says that this is why I fired him or dropped him as a client, because at the end of the day, he probably could care less that she dropped him. Just leave it. But the professional ramifications of someone of her status dropping you makes you a pariah to other managers. You understand what I'm saying?
I think that, and that's why I say he should sue her anyway for the abuse that happened beforehand. Because even if you got, I mean, we just got to, I like to think pragmatically. And this is what I mean by that is, where are we at right now and where do we want to be? He wants to be employable again. He's a great actor. I've seen his work. I loved him in Loki. I've seen his work, and he's a tremendous actor, actually, a tremendous man. I never knew who he was until I saw like his SNL appearance. I'd never heard of him before. Then I was like, this brother really is doing great things.
Oh, don't say that.
Yeah.
Not on the Martin Luther King Day. Don't say that he's doing great things.
Well, look, I'm just saying, at least in his profession, he's doing great things.
I think so too, but you know, hey. I think it's froze.
Yeah, I know my screen is.
Okay.
Sorry about the screen freezing. But what I will say is this: is that I think pragmatically, what he should do is litigate her assaults on him, because at that point he gets justice, and people get to hear the stuff that they never got to hear. Right. You know, hearing an interview on whatever, and people can always criticize that at the interview, but it's like, no, let's bring her in or interview her. But better yet, I'm going to sue her. And then even if he dismisses or if, you know, whatever, I mean, it's a gamble. But if he's like, she assaulted me and she's admitted assaulting me and I'm going to sue her, and maybe he wins on summary judgment, which is like, we ain't got to go to trial. A judge, upon hearing everything she said, goes, liability is established. Ma'am, you did it. We're just having a trial on damages. Well, at that point, that's a win for him, because he's been able to say, I get that a jury convicted me of these low-level misdemeanors. I mean, they're very low level, and of accidentally doing something. And I get all of that.
In the process of trying to escape your psychotic activities. And
and the prosecution didn't even charge her as they should have with the crimes that she's admitted committing against me, as we see by a judge. But we now see the two standards of justice that happen in America, not just for blacks and whites, but also for men versus women. Because you'll see many more men convicted of assaults against women when you got plenty of women assaulting men. All the time in public, you know, he's getting slapped on the face.
That's usually how a lot of domestic violence situations start. The woman usually slaps the dude or throws something at the dude, and he doesn't exercise appropriate self-control, and he just goes in on it. You know
and that's what I'm saying. And domestic violence is a spectrum, because I know there's times when people do actions because because you got guys who just half women murdered in America are killed by their former or current romantic partner. So men kill women regularly. Just for, and they're attacking. I can't get your phone number. Boom, you're getting attacked by some crazy dude. Then you got the incels. You got a whole bunch of stuff out there. But if he's able to get a judgment, well, I'm just saying you got to cover the thing, because the incels like, you know, no woman will even sleep with me. You know, so I want to kill all women. I'm like,
all right, so that basically was you putting it out there. So real quick, because I know you got to go. As far as this civil suit goes, should he have filed it first? Or, I mean, is there like really no way to know? Like, because he said, as you saw in the TMZ video, they saw it coming from day one. But if that's the case, then why wait for it to come? because do you do civil before your verdict? I mean, before your sentencing, before your appeal? Like, what is the because you can't ever predict when somebody's going to play their hand, right? You also don't want to overplay your hand or show your hand early. So it's like, now what? She's out here. So he's obviously going to countersue, and he can do everything that you mentioned in January.
Right.
But
I think waiting is good. And I'll tell you why. If he filed it before they went to trial, there might have been a stay, or who knows what would have occurred. So he may not have got to depose her and use her deposition testimony at his criminal trial, to the extent that is possible. I'm not saying it is in New York, but I'm just saying to the extent that it could have been. But that would have been viewed as, that would have played against him negatively. I mean, so that's why when in my little, seeing myself in my plaid shirt, just so you know, I love plaid. My family can't stand it.
I know.
I got
noticed.
I got a lot of plaid. I love plaid from fall till the first day of spring. I'm wearing
Good
plaid.
to know. So when I do my gift giving, I make sure it's plaid.
Double extra large, 37 sleeve length.
Okay, I got you. 37.
But here's the thing. Considering life after this, if he had filed a lawsuit beforehand, they might have, just given how the press does, they would have certainly played this as he's attempting to utilize and exploit the system and silence her. They would have used it to make him the bad guy or the worse guy than they've already made him. But by him doing this, when she files the lawsuit, it's like, okay, you got the trial. I'm doing the appeal. I'm waiting on this. But thank you for filing the lawsuit against me. Thank you. Because now I'm coming at you. But here's the thing. I'm coming at you with both barrels. I don't got to hold back at all. So if I came at you first and was going scorched earth, people would say, oh, he's abusive. And it would have been played with that abusive concept.
Right. And somebody said that in the comments, that he'd be seen as the bully.
Exactly. But you come for me twice. Now I'm not holding back. It's like, hey, look, I'm just telling you, as I tell my kids when somebody was, trying to bully them in school, I said, look, they touch you the first time, tell them don't do that again. And the second time, you tell the teacher, they touch me again.
It's on.
I'm just telling you, I'm not gonna complain the next time. I'm just hitting. So that's my point. Is at this point he has the position to go scorched earth. He's going to file his counterclaims. It benefits him. They get to those depositions, and God help him or help her if she starts saying inconsistent stuff. Because if she starts saying inconsistent stuff,
she can't help herself. She did it during the trial, but it made no difference.
But that's my point, though. But it now allows him to do what he's doing. It now allows him. I mean, maybe she told the prosecution some things that the prosecution didn't disclose to the defense. You can sometimes find misconduct by the opposing party in these collateral actions. This criminal case, the civil case, I should say, is collateral to the criminal case. It's separate, but it adjusts. Think of railroad tracks. It's same issues, same direction, but different tracks. But if we start bringing out stuff in that you kind of go, what, did you tell the DA this? Yes, I did. That's interesting because they didn't tell me this. You can get discovery. You can make her produce things the DA, we didn't get. Nah, I'm going to make you produce it. I get to inspect your phone. There's a lot of stuff. You have more rights in a lawsuit than you do in a criminal case. Right. And once you understand that, you'll see. So I feel like it lets him look for any prosecutorial misconduct claims that come up. It also lets them go and see what other inconsistent things she said. It lets him go scorched earth, or his lawyer go scorched earth. And every time something inconsistent comes out, it's got to be a, oh my God, kind of moment. Right. And then even if he loses his appeal, even if he loses all of that, public opinion, which is still watching, will have got to hear that. And now the question of, was he done an injustice, has a whole lot more weight behind it. Because then it becomes Jonathan Majors, who was convicted of misdemeanor battery, but showed that the victim lied many times during her trial and that she actually assaulted him. And the media will start saying she was found liable for attacking him, liable for assaulting him. Then the waters get a little more muddy. And I think it all gets on how it gets played out, but it definitely has an ability to make him more employable, in my opinion, in the future, because he doesn't come across as the bully. He comes across as
he's
look,
at this point, they're just constantly coming at him. And
right.
it's just, come on. Now, a question. This was asked earlier and I couldn't find it. That's kind of why I told y'all to wait till we got to this part, because there's hundreds of comments. Will we be able to see anything that was redacted during the criminal trial in the civil suit?
To the extent that somebody makes it available to you, yes. Meaning, because sometimes there might be a gag order, protect some other legal mechanism that prevents it from coming out, but nothing stops them from showing those text messages now. Quite honestly, I mean, she just filed a civil suit. The criminal case is over. Here's the text messages. I mean, there's nothing that stops that. We're putting them out there for y'all to consider. I mean, if you got access to them, if somebody on his side wants to give you those text messages, hey, here you go. Here they are. We're putting them out there. Even if his side doesn't opine on what they mean, the fact of the matter is they're out there and people get to have access to them. And you're just, because he hasn't responded to the civil suit yet. So it's like, I haven't responded to the civil suit yet, just got served. I am named as a party, but I haven't appeared before the court to subject myself to the court's jurisdiction, and hence any protective orders preventing the release of this stuff. So now is the perfect time to get that out there. And because, once it's out there, then it's like, here are all the text messages that were kept out. Here's all the stuff that was out there. Now I filed an answer. The judge says, don't divulge that. Man, you should have got me 2 weeks ago, because it's out there now. And I
know this has nothing to do with the civil suit, but I mean, I guess after the appeal or whatever, that body cam footage that the audio was stripped from, I'm guessing it hasn't been released because I'm sure that's part of the appeal. So that's probably not going to get released.
Well, make them do an open records, make them deny you pursuant to a freedom of information request. You would ask for, as a third party, you can ask for anything, and that most open records requests have an exclusion that when the case is being litigated, you can't get it, and maybe that litigation includes the appeal. But what I'm saying is, that's the body cam, only the body cam. But if you have it and somebody has it, get it. But as far as the text messages, that's on her phone and his phone. So you know what? You can hear it all. Now he's got to make sure he's giving you everything.
But they can subpoena whoever the service provider is and get all those text messages.
Not always, because sometimes the text messages aren't. I got a murder case with text messages. It gets from your phone. Most of the time, your provider doesn't keep the message. It just shows that there's a data transmission.
Right. It won't show the actual.
Precisely.
You can get a forensic person that if you try to delete them, they can pull them up though.
Off of your phone, because it comes to your phone.
They will delete. I'm sure she deleted all that stuff, but they can get somebody that forensically can pull it back out of the universe wherever it goes when you delete it.
They can go deeper than that. I'm gonna tell you something. Let's suppose they said that they were somewhere, and he says we were at this location. She goes, we never were there. On your phone,
location.
Not just location. It'll connect to a different network. So, like, if you came to my house and said, "Kirby, I'm at your house," and I'm like, can I get on your network? Sure. Here's the password to get in. Your phone itself will say this was one of the available networks was Clement's household. And so now that's on your phone. So if she says I was never there, and it's like, well, then what? So you never know what you're going to get off of the cell phone. But what I'm saying is, right now, whatever he's got on his cell phone, as the back and forth text, there's no reason. He can choose what to release. He can choose just to release her stuff, but there's nothing that prevents a party or a participant, I should say, in that action from releasing all of their text messages right now. And it's better to do it before he files an answer, because then he's gonna be subject to that court's thing. It's a jurisdictional issue, meaning, and there's some rules in there, but he can navigate that on his own. So I'm just speaking to you and not to him. But the general, I'm not giving legal advice, but the general point is this: when you get sued, someone says, I want you to come into this court who has authority to make a decision involving you. When you file your answer, you are submitting yourself to the jurisdiction of that court and saying, yes, court, you do have authority to make a decision on this matter involving me, and I'm now here for you to help navigate that journey. That's when you submit to the jurisdiction. But just because you have named me and I haven't yet filed an answer, I haven't submitted myself to the jurisdiction of the court yet. And if there's no protective order or anything that has somehow told the world and told me I can't do this, I'm gonna give it to you now, because once I file my answer, we'll be back to the whole redaction stuff. We'll be back to the whole court order and the gag orders. We don't gotta have any of that. You got it now. Here's what you got. Take a look at it. Insofar as the criminal appeal, I mean, on the criminal case, if the court says you can't do it, you can't do it. But I'm just telling you that he probably has way more room now to release those texts than he will later, or somebody who has access to those texts. In fact, why didn't she release them? I mean, that to me would be the big point. You need to release.
Why would they redact it? That's my question.
No, but see, that's the point. Why are you only releasing redacted?
What are you hiding?
Why are you only giving redacted text? And you can fire away with that. And that is a way to do it. But I'm just saying that there are ways to, just because you can't come in the front door doesn't mean the back door or the side door or the garage.
No.
Are other ways to get in. You know, you can definitely brumman, if you will, from Martin.
Right,
you know,
from the fifth floor.
Yeah, from the fifth floor. You know, but you can most definitely brumman stuff in to the court of public opinion before an actual court tells you you can't. And if it's important for you, then, and it's ethical, provide, you know, so I'm just saying, as long as you comply with the ethical rules, and that's probably, maybe his lawyer couldn't do it, but he could do it. That's why I'm trying to say the ethics of that have to be explored. But right now, I know at least 2 people have those text messages, him and her. We know that for a fact.
The DA and the defense have them too. They just wouldn't allow certain things in, and the stuff they did allow in was redacted. So I'm just like, oh, okay. But like Kat just said, in her civil suit, she completely skipped a part of the text that gave a little context to the fact that she was BSing and he did not hurt her, as some people seem to think that that's what it was leading to.
And again, that's a grounds for appeal as well. If you say, if their defense argument, and I mean, obviously they would have made that point at the trial, like, Judge, this part is redacted because we know what this says in its context. So, well, that's what I'm saying. I mean, but he would have had. That's my point. Is it's on his text. It implies that it's not there, is what I'm saying, or it implies that it doesn't give context. Because if the defense has I text you, you text me, and then you put up the text and you redact stuff, and my argument is, no, that's out of context. I need to be putting on the record what you left out is this, because the jury doesn't hear my argument. The judge hears the argument. Judge, these words are important and should not be redacted because of, in which case you would have heard it in court. But if the defense didn't make that specific argument of these words were taken out and it's important to give context, that implies to me either one, the context doesn't change what we saw. It won't impact that at all. Or 2, they dropped the ball. But I mean, but you know, so it's one of those 2. Either it was there and you should have told the judge and made a record so we had something to appeal, or, you know, it really wasn't there. And
I think it's less drop the ball and more taking for granted that people had common sense. Because like I said, this was a common sense, open and shut, hella reasonable doubt case. And I feel like in the defense of the defense, there was a lot of stuff that in hindsight, I'm like, y'all should have did this, this, and that. But then thinking objectively, I'm like, you really shouldn't have had to do this, this, and that, because that, and this superseded you needing to dot all those I's and cross all those T's. So I'm going to blame the jury all day, every day on this one.
Oh, now see, I'm gonna tell you, I take a jury all day, every day. I understand.
No, this jury, I'm blaming on this.
Yeah. No, I got you. But what I'm
gonna say, OJ jury.
No, yeah, I always want OJ jury.
There's 2 juries I cannot stand today: the OJ jury and the Jonathan Majors jury, for 2 completely different reasons, obviously. One was definitely guilty, and the other one was definitely not, based on reasonable doubt.
Now, what's funny is I talked to people that I know on the OJ case, and I respect, and they thought OJ was not guilty. And I was like, "What trial did you watch?"
And at the time, I was a kid, and I knew that was a slam dunk. I was actually going to John Jay College of Criminal Justice at the time. I just aged myself. Mind your business. But I knew, and I didn't even have cable at the time, because at that time we lived in the Bronx, and the Bronx didn't have cable at that time. They didn't get cable till like 2000 or something. And I was watching it on regular TV before Court TV went off the air and just recently came back on Court TV. And I knew that he was guilty then as a child.
Right.
So fast forward 30 years later, with all the stuff that we now know about forensics and evidence and this and that and the third, ain't no way that man didn't do that. Ain't no way.
I'm just gonna say this.
I know 47-year-old men that can do exactly what he did, because they don't make us like they used to.
Oh, no. I absolutely agree.
Like I said, I just aged myself, and
but you made me older, because you were like, I was a child, and I'm like, a child? I was a prosecutor.
I was a freshman in college, and I'm currently the age he was at the time that he supposedly committed that crime, and I know I could do it in the physical condition I'm in now.
Look, and I'm older than you, and I know what I can do. And I'm like, shoot, even I did something.
You could have done it, right?
No,
right.
But I'll say this. No, you pull for your, but here's the thing. With the jury in this thing, the one part that we have to acknowledge is, and this is the thing about law and how you got to proceed when you think about this. Forget the injustice, and I know that sounds weird to hear me say that. Forget all of the injustice, forget the facts, forget all of that. Mm-hmm. The question is, for appeal and the like, what is the rule, and can I show you that the rule was violated? The law, you're just connecting dots, and you're just like, well, rather than saying the jury was biased or the judge was biased, unless you got actual bias that you can show that affected the outcome, you're not going to win on that. So instead, you have to go with what was introduced that shouldn't have been introduced, and how did that prejudice it? Mm-hmm. What was excluded that shouldn't have been excluded? What are the specific? That's why I like their brief. They cited a pretty good amount of cases. They try to make some distinctions, but the key point is you're just looking for the trigger. You're just saying, did I hit the right button here based on this? Because if you get that on the things that are reversible, and you got to keep in mind this, and I'll take it from the case I just got reversed. Actually, my guy went, just so you know, I'm bragging. I know people might not think it's great bragging, but my client I represented him.
You did that.
He had been sentenced to 2 life prison terms consecutive without the possibility of parole, plus I think 45 years. That's what he had gone to trial. That's what he got. And then I turned around and we got it reversed on appeal. Now he just got 20 years, and he's already done 12. My point is that I had a bunch of reasons for appeal, like 27 of complaint. I'll say I had 27 complaints, but of those 27 complaints that I had, only 5 of them were going to work the kind that if the court agreed with me, was I going to get a reversal? And I got a reversal on 2. So I get the facts, I get the sauce, and I get that there are plenty of complaints about this, but you have to zero in on the things that the law shows you. If this took place or didn't take place and should have taken place, that is where the reversal comes. And that's the stuff that has to be handled. Now, you can bring up your other complaints, but bring up the best of those complaints around that, so that the court can get, or anybody listening to that can get the overall opinion of this was unfair, not because you disagree with the outcome, because the people that counted agreed with the outcome, but this was unfair because the outcome would have been different, but for these errors. And because of these errors, the outcome is bad. And so while I felt like the jury was biased against him, the reality is the jury reached the verdict that they were effectively steered to because they weren't allowed to hear certain things that would have put that in context. So that's when you go into the sufficiency or the errors. And also with errors, there's the issue of discretion. A trial judge has broad discretion. So the question becomes, did it rival a level of abuse of discretion such that it affected the outcome? So there's legal ways to just legal triggers. Error, yes, but not reversible. Keep it moving. Bad, yes, but not reversible. You got to go for error, reversible, or a bunch of other errors which put together equal reversible. And that's the way that you have to handle it on appeal. So the appeal argument is a whole different perspective. And there are grounds that, from what I've read here, and the jury charge and the justification issue, those to me are, and even the fatal variance, the alleged intentional, and it was really reckless, and there are no facts that could have given a reckless, that is important. And that's why I say New York appellate courts do, I mean, in Georgia, hey, I don't care. The jury found it. I mean, it's rare to win on, I mean, I've won on sufficiency of evidence before, and that was from a footnote that I cited. I didn't think it was my winning ground.
I remember that.
Footnote number 3, and I'm like, that's what I won on. I'll take it.
I'll take it.
Look, a win is a win. So that's how you have to kind of view this now, which is why I say that on the civil case, when you're going through the depositions and the like, even though the criminal case is over, and let's suppose he loses on appeal and it's just locked down, but you might find something along the lines that grants you extraordinary relief. You know what I mean? Like, there might be a text message where she says, you know what, I'm going to tell him he did this. Well, wait a minute now. You wrote down, I'm going to tell him he did this. That implies that he didn't do that.
And I would not be surprised if she wrote that down, because she's that obtuse. I'm telling you.
And that's what I'm trying to tell you, is that
because she texted her friend that she heard him trip over a suitcase when she was supposed to be unconscious. That came out during the trial. But you were unconscious. How did you hear him trip over the suitcase?
Exactly. And first of all, how would you even know it was a suitcase? Like how does a suitcase sound compared to?
She left it down there, and he supposedly tripped over it on his way into the apartment. She could, I guess she knew it was there, and she.
Well, no, she knew that there was a potential for him tripping over the suitcase, but he could have tripped on his own shoe. He could have, and so much he could have tripped on, but the suitcase, like, nah, that's
the idea that you were up though. You were conscious.
Yeah, exactly. No, that's what I'm saying. You were up and not just up and alert, because you were able to kind of go, I heard the sound. I know what that is.
Tripped over that suitcase I left downstairs.
Exactly. So, but now, and the next thing on appeal is, if you find out that she made statements inconsistent with her trial testimony, and if she had shared that information with the prosecution, and the prosecution didn't turn that over, that would be a Brady violation, and which is that the prosecution is obligated to produce exculpatory evidence to the defendant. Yeah, not what it doesn't mean that the jury may find it, but it tends to be exculpatory or impeaching under Giglio.
Yeah, they had to do a Brady disclosure because they had met with the driver and his interpreter the Sunday before he testified that Monday. And
right,
so
but
the jury in, they did that whole thing with
But that's the driver. I'm talking about her, because the thing is, it's what did you say? Because some stuff doesn't get written. If you send me an email, eventually I know they're going to get access to that email. You send me some document, but if you just told your prosecutor, look, it really didn't happen like that, or something, and then the prosecutor doesn't make a note of it, but then later on you come to trial, you're in a civil case and you testify, oh, I told the prosecutor that I didn't really know that I had cut, but I cut behind my ear, in the closet. Okay, who did you tell that to? I told the prosecutor. I mean, I didn't realize I was cut behind the ear, but I first noticed the cut. I'm just making this up, these facts. I first noticed it in the closet after I fell. All right, you first noticed that then? All right, who'd you tell that to? I told the DA. Now you're looking and you're like, well, the DA didn't disclose that to me because I would have been asking questions about that. So you can set up Brady claims or Giglio claims later that you can raise in like a habeas petition, something like that, or an extraordinary motion. So it's good that he did it the way he's doing it right now. I think he doesn't come across as the bully, and he can go extra hard on her now.
Because she showed her hand and she can't backtrack now and add stuff.
Yeah, exactly. Look, you drove me into a hole and I went to the hole and the world was fine with me being in a hole, but then you came in that hole after me. Things changed. I'm very brutal. I'm brutal in this hole. and I'm coming out and I'm brutal, legally brutal. I'll have my female lawyer slash, cut, and burn, and that's fine. But you're going to give it an account, and then she might, and if she crumbles, then the court of public opinion crumbles.
Right.
And then we all begin to question the outcome of the trial.
We're already doing that though. And they know it. Everybody knows it. That's why he's working now. I mean, he's not necessarily working on what we wish he would be working on, but he's working.
Right. No, he's working. But you want to get it to the point where it's like, if anybody says, what about Jonathan Majors? No, because you know what, not to compare him because they're not remotely similar. But he would like the Roman Polanski treatment by Hollywood, which is, Roman Polanski committed the crime. And
and they acted like they didn't see it. Like,
and they're all like, oh, he's a great this and a great that, and we're going to be at an awards. No, he wants that treatment with an acknowledgement that he didn't do what they said he did. Right. He was railroaded. That's what I'm trying to say. So again, and that also goes to, again, the court of record and public opinion and everybody else. I've not heard anybody really coming down on those people that supported Roman Polanski, despite his conviction and flight, and even the woman who's now an adult saying, no, that really did happen. And everybody's like, yeah, but he's a great producer. Okay. I just want to see how y'all play this out. So he's got a lot of room that he can work with.
A lot.
I think he's doing, even if they don't affirm, even if his conviction is affirmed, I think that enough will be able to come out to sufficiently leave people with the impression that an injustice was done, or that we can't have confidence in the outcome. We'll respect it because it's final, but we have no confidence in it. Right. And then that moves on, and then you move forward there. That's my Kirby Clements, non-public relations expert, nonetheless public relations expert opinion.
Exactly. I'm not a public relations expert either, but I feel like a conversation needs to be had about the current public relations situation going on, but that's a whole other issue. Okay, so last question, because I know Suzette, she's probably going to have my head if I'm ever in Atlanta. Would a civil suit ever require a jury?
Yes.
Oh, shit. I knew that was going to be the answer. I knew the answer, but I was hoping you was going to say no, because the law just recently changed. Okay, so.
Well, I mean, in New York, well, no, I mean, all civil cases have jury. I mean, I was a civil jury. Yeah, civil cases have juries. So.
Well, I mean, because we're used to seeing civil cases in the context of Judge Judy, where she'll just say, okay, dismiss, this case is dismissed. So there's the Judge Judy version with the propensity of the evidence. Yeah. And then you have the jury version where, like, for instance, I was called for jury duty for the first time ever on a neighbor dispute about feral cats.
Right.
So that was a civil case, but it required a jury.
So yes, he will have a jury, and think of it this way. What would be how different do you think people would see this if he had a jury and he won and was awarded? She lost, he won, and he was awarded substantial damages.
But I'm afraid that the same thing. Oh, but that's what I'm saying. But what if he doesn't? And then that's why we're back to square one again.
But if he doesn't win, it's okay. He gets to tell his story. Yeah. I get to tell you more before, and unless there's a gag order, you're gonna hear about it. And that's why I say right now. Again, not giving anybody advice to do it. If the ethics of it are that you cannot do it, then I am affirmatively saying don't do it. But if the ethics say that you can do it, I am affirmatively saying why would you not do it? Or I'm affirmatively asking that question. Right. I'm putting it out there. We're going to release the text. We're going to release the phone calls. I'm releasing voicemails. Everything is out there for you to hear, so that once people get it, they're out there using it and they're talking about it, and it's on the social media and all the sites and the influencers, and everybody's using it. And then by the time we get to the trial, it's all going. And so no matter what happens, it's going to have to be the civil case for him to come out bad. My take on it right now, and it could change, but my take right now is the evidence would have to be more overwhelming than it was at trial for him to come out on the worst end. If in a civil case, he comes out looking like an ogre, then it's like, dude, wow, the prosecution really kind of cut you some slack, and that's probably why they didn't offer you a deal beforehand. But if if the criminal case was her best foot forward, and that's as good as she's going to be, then he knows the worst that's going to the worst that'll happen is this is it, and that's the worst that can happen to me. And they've already heard that. Well, look, now I get to hit her back. I mean, I hit her back.
And hers can have a jury too, right? That $75,000 one she just filed.
Well, it'll all be one trial because he's going to file a counterclaim. So,
okay, got you. So
she files her claim. He files her counterclaim or cross claim, what do you want to call it?
And they're going to do it all together.
It's all together. We're going to do it right now. Let's go.
Okay, so you heard Kirby say she filed this civil suit last Tuesday. He's going to file, we hope, he's going to file a countersuit. They're not going to do these as separate trials. They're going to do it as one trial. Court. Say that again?
Because it's in federal court, I thought I said. I thought that's what
federal,
said.
Yeah. Mm-hmm.
Yeah, so it's going to be in federal court, a whole different ball game. Now, the federal judges don't play. I'm just going to tell you that right now. Federal judges are like, they do not play. They don't care about the public relations because they got a lifetime appointment. I ain't got to worry about that. I can make you mad, and guess what?
To be elected, right?
You'll just be mad. Now, that can go bad for you, or that can go good for you. But if you got a decent federal judge, you're like, hey, let's go, man. Let's hear it. And or they might find that it does not meet federal jurisdiction requirements. They'll kick it to state court. But right now, I think it's going to be federal court. So let's go. Federal court. What is the worst that can happen? Y'all get to hear the same facts again, or y'all get to hear some facts that are a little bit different. And just so we know, as I see somebody says $75,000 claim.
It says in excess of 75,000. So I guess 75 is the minimum. I don't know.
I think I got to look at the jurisdictional amount of federal court, but yeah, it used to be 75,000. You got to have diversity of the parties. We are diverse. We live in different jurisdictions, and the amount in controversy is, I think it's 75,000 should be the number, but there's a level of diversity.
Okay, gotcha.
I mean, when I say level of diversity, there's an element called diversity.
Right.
But yeah, and a jurisdictional amount. So if you got those two, you got federal court.
And why is it in federal? Barbara asked real quick. I know we just keep going and going. All right, y'all, we're going to have to.
Well, it's probably federal court just because of depends on her claims and where she lives and where he lives. Where is he a resident of the
state? Is only like 5,000 or 10,000, right?
No, state court you can file whatever. You got civil court in New York, which is I think up to like 10,000. And there's then there's the actual big time civil court, if you will, that is jurisdiction amount could be whatever. But a federal court, sometimes you pick federal court for different reasons, but usually you pick it because it's going to be faster. Federal court is fast, and the judges don't play, and it's the federal rules of evidence, which usually match New York's rules, I think. But also, there's just a requirement that it's necessary to get into federal court, which is like diversity. And maybe they didn't want to get stuck in the New York state court system.
Be going until I'm 60 years old if it got
exactly. You'd be like 47 years old. Jonathan,
I'm gonna be like Jonathan. I'm gonna need a retirement package because I've been doing this for a really long time.
Exactly. So federal court, you get going faster.
Yeah. Okay. Got it.
All right.
All right. Well, everybody, that's it. It's a wrap because we didn't held this man hostage for 2 hours and 52 minutes. I thank you, Kirby.
You are welcome.
I thank you for whoever's hungry right now because I did cook dinner at 3:00 because I knew. So my peoples are eating some spare rib tips as I speak, and I hope there's still some left because it's been a minute. But thank you, Kirby, as always. That's why I try not to. I don't create as much because I'm not a creator. I'm really not. I'm just trying to inform people. I'm trying to, stay on top of things within a timely fashion and not do things too early to where you forget about it. So again, Monday is the 1-year anniversary. 5 days after that is the date that the judge has to decide on a motion to set aside the verdict. If that's a bust, April 8th is the sentencing date. So as you see, this was a meticulously timed civil suit, but hopefully that does not affect anything either way. And we can hopefully soon move on after this expedient federal thing passes through. Right. So hopefully we can have a hot girl summer and not be dealing with this by June.
Well, I won't be having a hot girl summer because I'm a dude.
we female fans. We female fans can have a hot girl summer. I'm gonna
All
have a
right.
hot girl summer because I've been hitting that gym heavy. I know you saw my post, Kirby. Let them know about the guns and the buns, if you will.
Yeah, I see. Oh,
Not the buns.
Look,
the
she's not
guns.
playing, y'all.
I ain't playing out here, you know. So
The guns.
The guns ain't playing. That's
Look.
why, you know, I'm covered up because I can't reveal it right now. But yes, thank you.
We're not ready for the power. You know, I got you.
Yeah, y'all not ready for this. Thank you, Lauren. Thank you, Kirby. Thank you, everybody. Flavio. Thank you, Pam. Thank you, Kat. Who else? Blue. Everybody that's in the comments. Dre. Thank you all very much. Everybody, please like, share, comment. Look Kirby up in the show notes. Let me just get that again real quick for you guys. Kirby is licensed in New York, but he practices in Georgia, all over the state. Hit him up. Clements Law Group, right? ClementsLawGroup.com. I got that right?
ClementsLawGroup.com.
It's in the show notes as well. His IG is in the show notes. His YouTube is in the show notes. So please like, follow, give him a call if you need anything. And again, thank you, Kirby. Thank y'all, everybody. And hopefully, I don't know. We'll probably see you in another 6 weeks, depending on what happens on April 1st. Like I said, that's 2 days before my birthday.
Exactly.
I'm hoping that there's some good news. If not, then on to the sentencing. And then I guess me and Kirby will talk about that depending on what happens with that. If it's status quo, we won't really need to talk because it should only be probably community service, a fine, and maybe some probation, possibly less. If it's status quo, there's nothing to talk about. If it's time, then all hell's going to break loose. And I'm going to be there at the forefront throwing chairs. So be ready to post my bond, Kirby. All right, y'all. Y'all have a good week.
See you later.
All right. Good night. Bye.
Bye-bye.